Yes, my lord, my lady. Lordship, I have to mention item number 7 on behalf of NS Esmere. Lordship, today she's in bereavement, so can you list the matter after 2 weeks?
Item 7. Who is for item 7?
I am for item 7.
Yeah, item 7.
Yes, my lord. I was also informed, Lordship.
Your name is not here.
His name is there.
No, here, Lordship, unlike in in the principal said in other benches, the appellant stands here, Lordship.
No.
Item
His
7,
name is
full babu.
Acha. I'm looking at, this is a single bench. Oh, the single bench matter.
My lord, my lord.
Item 7. Okay. On the prayer for adjournment made on behalf of Miss N. Mere,
Esmere.
S. Mere, Leonard, additional PP.
PP.
Leonard PP? Oh, PP. Okay. Who is under bereavement? This is the matter after.
Lordship, if it can be fixed on 9th of December, my lord.
Any problem? 9th of December.
My lord, my lord.
On bill time.
Yes, my lord.
Okay. 9 December.
My lord. I am deeply obliged.
Lordship, I have a similar prayer for item number 6 on behalf of NS Esmere. 2 weeks.
Item 6.
Yes.
No. You will allow the thing and the delay. Delay will allow 1075 days.
Yes.
We'll allow this.
Lordship.
We'll allow this.
Lordship. Then item number 5. On behalf
I'll tell you why we're allowing.
Yes.
Because it's a criminal appeal. And now there have been directions and that, you see, appeals which have been rejected by the High Court and where the convict has not submitted any appeal to the Supreme Court. So those cases have to, after we talk to the convicts, we should send their briefs to the Supreme Court so that it is decided finally by the Supreme Court. So that is a kind of a mandate. So there is no sense in hearing a condemnation of delay application because there won't be any rejection, and it's a question of personal liberty, the basic human right. Okay, so we'll allow this. That's why I'm saying. Okay.
Lordship, then in next item number 4 on behalf 5, on behalf of Esmere after 1 week.
Yeah, for
And for the appellant item number 5.
item 5. Okay, right. Item 4 on the year for madam.
First one, number 2, item number 5.
Okay. Yeah, for the informant
Yes.
on the prayer made on behalf of Miss S. Mere, PP, who is under bereavement, this is the matter. After 2 weeks.
1 week.
After 1 week. And then the item 6, you write. Who is the additional PP? You are the additional PP.
Yes.
Okay.
PP, I'm also PP.
Who is in item 6? Who is there? Come. Heard Mr. R.N. Long,
Yes,
learned
Lord.
counsel for the applicant who submits that there's a delay of 1075 days for filing the appeal against the conviction of the applicant under section 6 or 4. But
Your Lordship,
under dash of the POCSO Act. Full stop. Mr.
Yeah, I'm gonna
K. Angami, learned additional PP, submits that he'll got no objection to the delay being.
Lordship, let me leave it to the discussion with the court.
Okay, submits that he does not have any comments to make in this matter. On considering the fact that the matter pertains to the personal liberty of a convict, we are of the view that the delay of 1075 days should be condoned. Accordingly, the delay is condoned. I is accordingly disposed of. Then next, on the main appeal, you write, heard Mr. R.N. Long, learned counsel for the appellant who submits, give me the fine. Submits that the impugned judgment dated
15-9.
the judgment and order dated 15/9/2022, passed by the learned special judge Pokso, Heck, Nagaland, in sessions bracket special case number 02 of 2022. In GR number 2 of 2022, arising out of Woman PS Heck case number, Woman PS Heck case number 01/2022, comma, convicting the appellant under section
Under section. Your Lordship, kindly bear with me.
huh?
Under section, it was 7, 6, 8, 9,
What?
10. It was convicted under a series of sections.
Where, show me the judgment. Where is this conviction?
Your Lordship, the operative portion is at page 40. 49 is the order of sentence, Your Lordship.
I think it's under this page 39, para 30 at the bottom. He shall be said to have committed aggravated sexual assault within the meaning of section 9 bracket 1 bracket M bracket N. Okay, I think this is the one, no?
No, for that also 7, 8, 6 are also,
No,
But-
no. How can it be?
and a combination of that,
You see, section 6 would apply. Or the below 12 years or what?
life imprisonment till death with fine.
The victim is below 12 years,
Yes,
below 12.
yes, Lordship.
So if it's below 12 years, then aggravated penetrative sexual assault will apply, not 9. So the 6 will be enough. 5M, that's under 5M.
Yes, Lord.
Then where's the question? The problem is this.
10 is also
Oh.
attracted.
Oh, here. 8 and 10. Page 42.
8, 9, and 10.
No, it says 8 and 10. Acha.
8, 10,
8,
12.
11 also.
Yes, 12 also. All the sections and cumulatively the sentence was passed.
Hmm. No. It's only 10 and 12. Only 10 and 12. Because 10 and 12. You see, at the time of sentencing, also not mentioned the under what section.
Yes, Lordship. Not mentioned.
Hmm. He shall be said to have committed under 9 also, 9, 1, no, 10 and 12. Let's say 10 and 12. Huh? 10 and 12. The book said. Admit the appeal, call for the TCR, issue notice returnable in 4 weeks. Mr. K. Angami, additional PP accept notice on behalf of the state. The appellant shall submit a soft copy of the appeal to the office of the PP, who shall thereafter forward the same to the concerned OC of the police, of the concerned police station. The OC shall thereafter furnish a copy of the appeal to the respondent number 2 and make a report with regard to service of notice upon the said respondent number 2. List the matter to 4 weeks.
Much obliged.
May it please your lordships, I beg to mention item number 8 on behalf of Mr. Tushio Longkumar. Yes, your lordship. So during the course of this trial, her ladyship, Justice Y. Longkumar was she presided over the trial. So I pray that the matter may be listed before another
Did she
bench.
pass the judgment?
No, not the judgment, but during the examination under section 313.
How does that,
Pardon?
how does that matter?
No, even on the 14th of May, this honorable court passed an order whereby the registry was directed to list the matter. Yeah, before another bench.
Okay, right. I'll list the matter before another bench, and not before one of us. Bracket, Justice Kumar, huh?
Much obliged, lordships.
For motion, item numbers 1 and 2.
May I please, lordships?
This is under 6.
My
Under
lord, yes,
6.
yes,
Huh? Under 6 POCSO.
yes, my lord.
Okay, heard Mr. Takakichu, learned counsel for the appellant, who submits that the judgment dated 26/9/2025 passed by the fast track special court Dimapur in case number
GR number 3954.
in GR number 354/2019 arising out of Women PS case number 40 of 2019, by which the appellant has been convicted under section 6 of the POCSO Act, should be set aside. Admit the appeal, call for the TCR, issue notice returnable in 4 weeks. Miss Livika or is there anything before Livika? No, only Livika. Miss Livika, learned APP accepts notice on behalf of the state. Then the same thing, huh? That give a soft copy to office of the
My
PP.
lord. My lord.
Then
lord.
in the IA, madam, how much time? Okay, right, Miss Livika, additional PP is granted
2 weeks, my
4
lord.
weeks time to file written objection to the application under section 430 BNSS. This is the matter of the 4 weeks.
My lord, can it be taken up for?
You have to, for bail,
Uh,
you have to give notice even to the informant. So when we have given 4 weeks in the main appeal, naturally follow here.
My lord, the appellant herein, he is suffering, he is sick. And as such, he was taken to hospital twice after his conviction and after he was kept in the central jail. He
Suffering
was
from what? Suffering from what?
he has gallbladder stone and fatty liver. So he was taken to hospital
Fatty
twice.
liver, jail food will be very good for him because they won't be very fatty. But gallstone, yes. You obtained.
He was advised for surgery also.
Huh?
To seek the opinion of the Board of Justice.
Okay, so
So if we can give a try on 10th of December.
what? Okay, then now you say, in the IA, huh, you say, the applicant's counsel submits that the applicant needs to have his stones in the gallbladder.
Yes,
removed.
yes.
Besides the applicant suffering from fatty liver. Full stop. Ms. Livika shall obtain instructions with regard to the same from the concerned jail authorities
Yes.
and the doctors concerned. List the matter on 10th.
Much obliged.
For motion, item numbers 3 and 4.
Okay, right. Yes, no objection, no? Heard Mr. Moa Jamil, learned counsel for the applicant who submits that there's a delay of 1 to 3 days in filing the appeal against the judgment convicting the applicant under section 4(2) of the POCSO Act. and sentencing him to undergo 20 years rigorous imprisonment with a fine of rupees 10,000, in default, rigorous imprisonment for 6 months.
Lordship.
Ms. Levika submits that she has got no comments to make in the matter as it concerns the personal liberty of the appellant. On applicant, on considering the grounds taken for the appeal and for the delay in making the making the appeal, and on considering the fact that the matter pertains to the personal liberty of an individual, we are of the view that the delay of 1 to 3 days should be condoned. Accordingly, the delay is condoned. I is accordingly disposed of. Then, in the main case, you're right. Heard Mr. Muajabil, learned counsel for the appellant. This is an appeal against the judgment dated 29/4/2022, passed by the learned fast track court POXO, Dimapur, Nagaland. Where is that? In
Year number 425 of 2020.
GR number 425 of
2020, Lordship.
2020? 2020?
Yes, Lordship.
2020, arising out of Dimapur Women Police Station case number
019,
19 of 20.
19 of 20.
19 of 20.
19/20, Lordship.
19/2020. Okay. By which the appellant has been convicted to rigorous imprisonment for 20 years with a fine of rupees 10,000, in default, RI for 6 months. Admit the appeal, call for the TCR, issue notice returnable in 4 weeks. Ms. Levika, additional PP access notice on behalf of the state. Then that same thing, you give the soft copy to the
Lordship.
office.
Lordship.
Then in the any IA,
No, Lordship. Obliged.
For hearing, item number 9.
there's all agenda.
May it please your lordships. Lordships, this is a case regarding to PIT NDPS detention under PIT NDPS case. I was detained on the 23rd of February 2025. And the materials on which
23rd of
February 2025.
Okay, 23rd of February 20.
Yeah. And thereafter, on the 27th of May, I was granted bail by the Special NDPS Court, your lordships.
When, which date?
27th of May, 27/5/2025.
Bail.
Yes. And while I was on bail on 5/6/2025, the detention order was passed against me, your lordship.
But why you were detained in February for what purpose? For what reason?
The only material on which I was detained was the disclosure statement of of the co-accused. Nothing incriminating was found in my person or the vehicle I was driving. I was only accompanying the co-accused in a different.
Okay, you were arrested.
Yes, yes,
23 to 2025.
yes, your lordship.
In a NDPS case.
Yes, your lordship.
And you were granted bail on 27/5/25.
Yes, your
Then?
lordship. Then the detention order, while I was on bail, the detention order was passed on 5/6/2025, your lordship. And the fact that I was released on bail was either withheld or suppressed by the sponsoring authority. And it was not brought to the notice of the detaining authority. And also on the part of the.
Let us see the detention order.
Yes, your lordship. Lordship, the detention order is at page 20, annexure 3. And the grounds of detention, your lordship, is at 88, page 88.
This is what date?
It was on 5/6/2025.
Who is this co-accused Abdul Ali? It is in that criminal case,
Yeah, he's the co-accused, Your Lordship.
in the criminal case, in the NDPS case.
Yes, Your
where
Lordship.
You are granted bail.
Yes, Your Lordship. And he has also been released by a coordinate bench of this court. He was also detained, Your Lordship.
Asha, he was detained or arrested? He was also
Arrested and
bail
later
granted.
bail was granted only to me, not to him.
And then
And he was arrested, later detained.
When he was in custody, he was again detained.
Yes, Your Lordships. And then he was released subsequently by a coordinate bench.
okay.
I have the order with me here
Yes,
also.
please.
So, Your Lordships,
Just a minute. Under section 3(1), let us see this 3(1) for the PIT NDPS.
BNS, I think, the 3(1) is section
No,
under.
no. Let us see this section 3(1) of the PIT NDPS Act.
Lordship, if I may read.
Yes, sir.
The central government may, if satisfied that it is necessary or expedient to do so on the basis of the information and evidence which has become available to it with respect to the nature and of effects of and the abuse or the scope of the abuse of any substance, natural or synthetic, or natural material, or any salt or preparation of such substance or material, and the modifications or provisions, if any, which have been made to or in any international convention with respect to such substance, natural material or salt or preparation of such substance or material by notification in the official gazette, add to or as the case may be, omit from the list of psychotropic substances specified in the schedule such substance or natural material or salt or preparation of such substance or material. Your Lordship, may I proceed, Your
Yes,
Lordship?
yes.
Yeah. If I may draw Your Lordship's attentions to page 88, annexure 16, these are the grounds of detention.
Yes.
Your Lordship, the law in this regard, when a detention order is challenged, the law in Huidrom Kunan Johnson, it is well settled that the detaining authority has to satisfy.
Who is the petitioner here? He's the.
Is the wife of the detainee, Your Lordship. So the detaining authority has to satisfy whether there's an awareness, whether the detainee is under custody or is eminence of likelihood of release and continuation of prejudicial activities post his release. If I may draw your Lordship's attention to para 3 of the grounds of detention, Your Lordship,
Yes.
that you are presently under judicial custody. This is not true, Your Lordship. I was already on bail. The special court had already released me on bail. And this aspect, it is evident from this fact that this was either withheld or suppressed by the sponsoring authority and even the detaining authority.
That is a different issue. Now, next issue.
And the second issue is the detaining authority failed to look into the fact as to whether there was any likelihood of release. And thirdly, that after release, whether the detainee would continue with his prejudicial activities, similar to his
Says that you are likely to indulge in similar prejudicial activity.
Yes, but I do not have any past criminal antecedents, Your Lordships.
Right.
No past criminal antecedents. So the grounds of detention itself suffers from this non-application of mind and for suppression of material documents, which could have weighted on the mind, subjective
Let us see
satisfaction.
the bail order.
Yes, Your Lordship, this bail order, I had filed it by way of an additional affidavit. There will be an additional affidavit, Your Lordship.
Okay, it's smaller.
May I read, Your Lordship? May I read, Your Lordship, the bail order? IA number 301 of 2025, taken up for hearing jointly today. Learned.
No, you see, you were in a vehicle where the drugs were seized, correct?
No, it was in the other vehicle driven by the co-accused. Nothing incriminating was found in my person or in the vehicle that I was driving also, Your Lordship.
So then you were arrested because the other person
Disclosure statement of the co-accused.
said that you were
Yes.
you were the owner.
Yes, Your Lordship.
But whether the issue is
Uh-huh.
whether the evidence of a co-accused is admissible as evidence.
I fall under the protective sweep of Article 20, Clause 3, Your Lordship. I cannot be a witness against myself, Your Lordship. If the basis of that,
You have missed the point. There is a law
yes, Your Lordship.
which says,
Mm.
decisions of the Supreme Court say that a statement made by a co-accused
Mm.
against another co-accused
Mm.
is not admissible as evidence.
Mm. Yes, Your Lordship.
Have you seen that judgment?
No,
No.
no.
Then, madam, what to do?
As far as the value is concerned, Your Lordship, the petitioner, I mean, my learned friend is actually stating that we have withheld or suppressed, but however, Your Lordship, that may not have been intimated to the government, that's why Your Lordship.
Okay.
It is,
That
I
is
mean,
a-
it's not about.
Has he got any antecedent earlier case under NDPS?
Even in the seizure and arrest memo.
There's sometimes we have to talk to the other side.
The grounds, in the grounds of detention, Your Lordship, that
You
is.
see, there was never any similar activity done. He was caught in one case. How can you come to finding that there was, that he might indulge in similar activity?
That,
If he's a habitual offender or criminal antecedents,
Yes,
that's a different thing.
yes. Out here, how can you say that?
to that extent, Your Lordship,
Huh?
to that extent, Your Lordship, a little bit can be given, kept there because on the ground of detention is lost. There is no reason to.
So this detention can be given for how long? This detention, how long can you detain a person under this PIT?
3 months and
3
it
months,
keeps on
they keep
extending.
extending.
So this was on June 25, so it has been extended again.
Yes, it was extended.
Let us
and
see
we
the
tried to
extension.
Take up the matter
Huh?
on 5 or 6 occasions. However, because of the inconvenience of the court, or sometimes
Now we take it up.
we could not able to take up. That's why now the delay battery is coming up, Your Lordship. So it was extended, Your Lordship, and
Let us see the extension.
It's,
Charge sheet has been filed or not in the criminal trial?
I'm sorry, Your
Has
Lordship.
charge sheet been filed?
Uh,
Charge sheet.
no, I'm not aware of any charge sheet been filed so far.
the.
So you see, even if it is a commercial quantity, how much time is given for filing charge sheet?
Like 180.
180.
180 180 days.
180 days is how many months? 6 months. 6 months expired in August. So even under 167, entitled to bail. In all counts, how, let us see the extension.
Yes, Your Lordship. It will be at
No page.
209, page number 209.
209.
Just an adoption of the same order passed by the detaining authority on.
8 September. 8
Yes.
September.
Yes, sir. May I read your?
No, it's okay.
That copy.
Oh. Yes, you can read.
Yes. Mr. Saddam Hussein, so and so, son of so and so, has been detained under PIT NDPS.
No, come from whereas.
Okay. Where is the detention of the said détenu, Mr. Saddam Hussein, son of so and so, was referred to the PIT NDPS Advisory Board constituted by the government of Nagaland under Section 9 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. And whereas the advisory board is of the opinion there is sufficient cause for detention of the détenu under the PIT NDPS Act 1988, and that the continued detention of Mr. Saddam Hussein, so and so, would be necessary in order to prevent him from further indulging in illicit traffic in narcotic drugs and psychotropic substances, warranting his detention under the preventive law. Now, therefore, the state government, in exercise of powers conferred by Clause F of Section 9 of the PIT NDPS Act 1999, hereby confirm that the detention order issued in respect of the said détenu, Mr. Saddam Hussein, so and so, and further order that he shall be detained for another period of 3 months with effect from 9/9/2025 till 8/12/2025, within which period his detention will be reviewed as required under provisions of the PIT NDPS Act 1988.
The basis for saying that he might indulge in,
The mere ipse dixi statement, it's just,
well, I think.
oh, I'm sorry, Lord.
Madam,
That we could not able to find in the documents.
so you could not substantiate to your own reasons. There's no justification for saying that. So any order passed, which is, which without any reasonable basis is arbitrary. That's no,
There's no reason being given.
there's no reasons. Yeah. So we just set it aside.
Yes, yes, yes. Yes.
Correct. Heard, Mister?
Kohima, your lordship.
For the petitioner.
Yes, your lordship.
Also heard Miss Levika, additional PP. The petitioner, yes, anything to say? You've got nothing to say. Acha, Mr. Yangarwati appears for the Union of India. The petitioner is aggrieved with the detention order number CON/PIT NDPS /11/2025/145 dated 5/6/2025. Passed by, and the impugned confirmation order number CON/PIT NDPS /11/25/209 dated 8/9/25. Acha, the first one was passed by the Special Secretary to the Government of Nagaland, Home Department, Political Branch, Nagaland, Kohima. And the second one by Chief Secretary to the Government of Nagaland, Kohima, along with, that's Kohima, okay. By which the petitioner has been detained, has been put under detention. Under Section 3 of the PIT NDPS Act, 1988. The facts of the case in brief is that, where is the facts of the case? Is that, where is the,
It's annexure 5, page 22.
no, that's not, page 22.
Yes, your lord.
No, that NTPS case.
Yes, yes. It's.
Where are the card numbers and what? Okay, let me ask you,
Yes.
who was the co-accused? What is the name of the co-accused?
Abdul Ali, your lordship.
Abdul Ali.
Ah.
And Abdul Ali was driving what car number?
It's.
Okay. The brief facts of the case is that Abdul Ali and the present petitioner, Saddam Hussein, were intercepted and apprehended by the Nagaland police along with the vehicles that they were driving, that is vehicle number, that is Bolero pickup bearing registration number AS 12CC 5411 and Scorpio bearing registration number AS 01A R 2041. Next para. In the vehicle that was being driven by Abdul Ali, yes. That is, which one did he drive?
The Bolero pickup.
The in the vehicle that was being driven by Abdul Ali, that is the Bolero pickup, comma, 50 soap cases of suspected heroin weighing approximately 581.88 grams were recovered. No drugs were recovered from the vehicle being driven by the present petitioner, Saddam Ali. Full stop. However, on the alleged disclosure made by the co-accused Abdul Ali
Yes.
against Saddam Hussein, to the effect that Saddam Hussein was the owner of the drugs recovered, comma, the petitioner was arrested along with Abdul Ali on 23 to 2025. And a case was registered by the Newland Police Station as Newland PS case number 003/25 under section 21 bracket C NDPS Act, read with section 3 bracket 5 BNS. Pusta. The the petitioner was granted bail by the court of the special judge NDPS Dimapur, by order dated 27/5/2025 in GR number 88 of 2025, by holding that the enforcement agency had not complied with section 47 BNSS. Accordingly, it granted bail as the non-compliance with section 47 BNSS was in violation of the judgment of the Supreme Court in the case of Vihan Kumar versus State of Haryana, 2025 SCC online. SC, it will be again SCA, SC 269. Okay, SCC online, SC 269. Yes. First one. After the next para, after the petitioner was granted bail on 27/5/25 by the special court, the petitioner was placed under detention by the state government on the basis of the grounds of on the basis of communication dated. Where is the order? The communication dated 5/6/25 made under section 3 bracket 1 of the PIT NDPS Act, 1980, issued by the Special Secretary to the Government of Nagaland. The PIT will be the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, 1988. Hereinafter referred to as the PIT and DPS Act, 1988. Okay. Next. The communication dated 5/6/25 shows that the authorities were under the impression that the petitioner was under judicial custody. The petitioner was put under preventive detention. On the ground that the petitioner was likely to indulge in similar prejudicial activity unless he was prevented from doing so by way of the communication, impugned communication dated 5/6/2020. The operative portion of the communication dated, impugned communication dated 5/6/2025, which is at para 3, is reproduced herein below as follows. Page 88. Next para. The Chief Secretary to the Government of Nagaland thereafter issued the confirmation order dated 8/9/2025, stating that the PIT NDPS advisory body constituted by the Government of Nagaland under Section 9 of the Prevention of under Section 9 of the PIT NDPS Act, 1988, was of the opinion that there was sufficient cause for detention of the petitioner under the PIT NDPS Act, and that the continued detention of the petitioner was necessary in order to prevent him from further indulging in illicit traffic in narcotic drugs and psychotropic substances. By way of the impugned confirmation order dated 8/9/2025, the petitioner's preventive detention was extended for another period of 3 months, with effect from 9/9/25 till 8/12/2025. Next one. The learned counsel for the petitioner submits that when there has been no case against the petition, where there has been no other case against the petition except for the present case, that is GR number 88 of 2024, 25, 88 of 2025. There was no basis for the respondent authorities to come to a finding that the petitioner was likely to indulge in similar activity. that is in the transportation of drugs. He further submits that when there was nothing recovered from the vehicle of the when the vehicle driven by the petitioner, the petitioner could not be the petitioner could not be said to be guilty of being the owner of the recovered drugs on the basis of a statement made by a co-accused, which was inadmissible as evidence. That's the exact words, correct?
Yes.
Okay. What is the judgment?
I don't have it ready, Your Honor.
Okay, yes, he accordingly submits that the impugned communication and confirmation order being without having been made without any basis, there is no justification for, there is no justification for the continued detention of the petitioner. So stop, Miss Livika, the learned APP, on the other hand, submits
My submission on the bill may be reflected as well as.
On the bill?
The report.
Huh?
My, counsel for the petition was stating that like there was suppression and, withholding of that bill application, I mean like, granting of bill application. It was not known, but it is, maybe because of the miscommunication, it was not.
I'm not on that.
Okay, and
I'm not on that.
like-
I'm only on that communication, that preventive
Petition is
detention.
concerned like, apart from the reports, there is no grounds, there is no grounds taken. in the report.
Yeah, brother records.
Yes, sir.
There's nothing there. Miss Livika, the learned APP, who has brought the records, fairly admits that there is nothing stated in the records as to the grounds for for issuing the preventive order of detention against the petitioner
Regarding the past antecedents.
regarding the past antecedents of the petitioner. She submits that there is nothing in the records to show that the petitioner had indulged in any similar activity of transporting or selling drugs in the past. That's all?
The report.
Yeah, as per the record. So you are safe that way. Okay, one more thing you write, for Mr. Mr. Pokim Yadin, Mr. P. Yadin, learned counsel for the petitioner further submits that the co-accused Abdul Ali has been released on bail.
Yes, yes.
Thus submits that while the co-accused was in judicial custody, a similar preventive order for detention had been issued by the state respondents while
The WPC Criminal Section of 2020.
You're not listening to what I said. The preventive order, the detention order. Now, preventive order of detention dated 8/4/2025 had been issued by the Special Secretary Home to the Government of Nagaland. And the same was confirmed by a confirmation order dated 10/7/2025 issued by the Chief Secretary to the Government of Nagaland. However, the co-accused Abdul Ali has been released on bail. And however, the detention order dated 8/4/2025 and the confirmation order dated 10/7/2025 has been set aside and quashed by a coordinate bench of this court. While judgment and order dated 4/9/2025 passed in WP Criminal 17 of 2025. On the ground that on the ground that
There are 14, Your Lordship.
on the ground that the reasons in support of the satisfaction of the authorities about the possibility of the detainee being released on bail was not sufficient in terms of the principles laid down in the judgment of the Supreme Court in the case of Huidrom Ponuja Singh versus State of Manipur, reported in 2012, 7 SEC 180. Wherein it had been held in para 9 as follows. It is here. In para 15, para 19, then I have para 15. The next para, the coordinate bench thus held that the detention order suffered from infirmity. On considering the facts of this case, we find that the petitioner had already been released on bail on 27/5/2025. However, the detention order dated 5/6/2025 has stated that the petitioner was presently under judicial custody. Further, there is nothing to show that there was any past incident or case showing that the petitioner had been accused of indulging in any similar activity of smuggling of drugs. The above two facts clearly point to the fact that the respondent authorities had acted mechanically while passing the detention order, and they had not applied their minds while passing the detention order and the confirmation. When the reasons for the detention and confirmation order are made without any supporting reasons. The grounds for the detention order and confirmation order would have to be held to be arbitrary. And as such, we are of the view that the impugned detention order, preventive detention order and confirmation order are cannot be sustained. They are accordingly set aside and they are accordingly set aside. Original, first of the original records. That's all, not that's all. The writ petition is accordingly allowed.
Oblige, Your Lordship.
That's all. No, no, no.
Your Lordship, I'd like to mention item 6. Your Lordship, here I need to receive instructions, so.
Okay, Miss Levika is granted how much time?
Lordship, 3 weeks.
Is granted 3 weeks time to obtain instructions and file affidavit.
Lordship, there is also another analogous matter with this matter, WPC number 171
So
of
you want to keep it
2025.
together.
Yes, Lordship.
Okay, list this matter after 3 weeks along with WPC
171, 2025.
171, 2020.
May I please, madam? Lordship, I beg to mention item number 5, Lordship.
5.
Yes, I'm here to receive instruction in this matter, Lordship.
Okay, Mr.
And I'm Lordship.
N. Angami, Learned Counsel for the state respondents is granted
3 weeks time.
3 weeks time to file affidavit in opposition. This is the matter.
Deep organization.
Please, Your Lordship. Your Lordship, I'd like to mention item 3. In this matter, we are still waiting on the verification report from the DC.
Okay, Mr.
For someone. M. Longkumar.
M. Longkumar is granted 3 weeks time to obtain instructions and file affidavit.
My lord, as a short prayer, the state council have taken sufficient time. So if my lordship may kindly direct the state respondent to finish the verification within 3 weeks, I say please.
What is the matter about?
Land ownership, to verify the land ownership. They said, they claim that they have an oral agreement with the department. So we need to verify that, and also they have not mentioned as to the year of when they gave the land. So we need to verify that.
This is the matter on, we'll give a date, which date? Date.
5th December.
5th December, comma, by which date it is expected that the verification of the petitioner's land should have been completed by the DC,
Yes, this is an photo.
by the DC Zonabado.
Hello, my lord.
Ma'am, please, Lord. The Lordship, I would like to mention hearing item number 11. Your Lordship. I'm for the respondent number 6 for the private respondents. Lordship, there are having some personal difficulty, so this matter will be fixed next week, Your Lordship.
11.
Hearing item number 11, Your Lordship.
No, you're for whom? You're for the respondent number 6.
Yes, for the private respondents.
You wait. It's a small issue. Wait, yes,
I also mention on behalf of Abidali for the state.
item?
Item 11, Lordship.
Yes.
The personal difficulties, Lordship.
Huh?
She requests for the difficulties, so
Who has personal difficulties?
Abidali for the state, Lordship.
Why? Who is for the petitioner?
Lordship, I am for the
This
petition.
is a matter regarding appointment without
Appointment,
advertisement. Correct? This
Lordship.
matter nothing.
Lordship.
It's a one-line order. You know the law. When do you want? Tomorrow?
This matter will be fixed next week. Your Lordship.
No, I'm sorry. Who is the council? You're the council.
No, Your Lord.
Taka Kichu is the council.
Lordship.
You're for the thing. And you're for, who's this? What's your name?
Your Lordship, Jinyam Hong.
Your name is not here. Huh?
Yes, Your Lordship, it's not listed.
But your name is the Bakad Nama.
Yes, Your Lord.
Yeah,
But the Arcane Council will be Yarnawadi, Your Lord.
Yangarwati.
Yes, Your Lord.
Where is he? Was he here earlier?
Yes, Your Lordship. But he just left the court. So-
Sorry, if he leaves the court, we'll just pass the order. We can do it both ways.
And it is matter be listed tomorrow, Your Lord. It is not to be passed over, Your Lord.
Okay, right. We will do it day after tomorrow. Tomorrow is DB matter. Day after tomorrow, but you all be there. If you all do not come, no adjournment is going to be allowed. The law is clear. I think they know, I think you all know the law. That's why you all are trying to avoid. Right. Item 11. On the prayer of the councils for the respondents. List the matter on Thursday. The matter pertains to the respondent number 6 having been appointed without any advertisement being issued by the city. List the matter on Thursday. You read State of Orissa versus Mamata Mohanty, very clear. Para 35-36.
Yes, Your Lordship, may I please, Your Lord. Similar prayer in item number 13, Your Lordship. This matter could be listed on Thursday, then, Your Lordship.
13.
Yes, Your Lord. Hearing item. Consent has been taken from all.
Lordship, if it can be taken up on Thursday, Lordship.
On the prayer of the council for the respondents, list the matter on This is with regard to land ownership. Who is the landowner time?
No, Lordship,
Again, terminated.
yes, Lordship, and an approval was issued by the government to terminate my service, Lordship. And there's an intention to replace me by the private respondent, Lordship, on the basis of land ownership, Lordship.
So whether he's the original landowner or he's the second
Lordship, by
landowner?
the approval, it clearly states that this is not a post which has to be, which is reserved for the landowners, Lordship. And
Okay, item 13, list the matter, the parties list the matter on Thursday. Thursday.
Obliged.
Lordship.
Lordship, I beg to mention item number 4. On behalf of the legislative division, Lordship, can you grant 3 weeks time to file a complaint?
Okay. Yes, Miss,
Bichano. On behalf of the
I'll just,
legislative.
okay, right. A genuine prayer has been made on behalf of the additional lady. On the ground that they need, how much time? 3 weeks
3
time
weeks, Lordship.
to file affidavit opposition. Praise allowed, this is a matter of 3 weeks.
Obliged.
Lordship, item number 7 as well,
My
Lordship.
God.
On behalf of Kiba. Can you grant 3 weeks time to file affidavit?
Madam, this way all the entire causes will be adjourned.
Your Lordship, there's an interim, so I pray that the interim order may continue until the next written on day.
What is the matter, madam?
Your Lordship, I'm not acquainted with the facts of the case. I was merely instructed to appear on behalf of the petitioners counsel.
Petitions counsel is a senior.
I'm not my senior, Your Lordship, but due to some personal difficulties on her part, I was instructed to appear.
There's so many of them. Zed Zimomi, Lovikato, Su, Zotamo, Ikon, Populi, Newton. None of them are here.
No, Your Lordship.
On the prayer for adjournment made on behalf of the petitions council, this is the matter after the week. After 4 weeks.
An interim order may
4
continue.
weeks or 4 weeks?
Lordship.
That's all.
Yes, Your Lordship, also,
Interim order to continue till the next.
much obliged, Your Lordship.
Lordship, I also like to beg to mention item number 12. On behalf of.
How many more are you going to tell me beforehand? How many more are you going to mention? This is not done, madam. Item 12, I'm not adjourning, sorry. If you're not there, I'm going to dispose of.
Lordship, the council is
Huh?
not present today, Lordship.
Who?
She's in Britain, Lordship.
Who?
It's Mary, Lordship.
It's okay, the petitioner's counsel is there. I'll hear the petition.
Lordship, since the state respondent, they have requested us that they won't be able to take up this matter today, but the leading counsel.
Okay, we'll listen on Thursday.
Lordship.
Right, on the prayer for adjournment made on behalf of the respondents, this is the matter on Thursday. Full stop. The matter pertains to the removal of the petitioner from service on account of the petitioner having admitted to the charge in his written statement of defense in relation to the departmental proceeding initiated against the petitioner. Full stop. However, the petitioner having been acquitted in the criminal case, the petitioner has now made a prayer that he should be reinstated into service. That's your case? Okay. Thursday, this is the matter on Thursday.
Obliged, ma'am.
Please, Your Lordship. Lordship, if item 15 can be taken up right after the admission item, Lordship. Is the matter regarding husband and wife. Yesterday, my senior agent Mimi was there.
Let it come up now, in turn.
It might not.
Already there are hardly any cases left. I mean, just 1, 2. There are not much cases. We'll see. Oh,
May it please your lordship. If I may be allowed to mention item number 10, your lordship, for hearing your lordship. Lordship here, the leading counsel is in dispose of your lordship. If the matter can come up on 4th of December, your lordship.
no. You tell me one thing.
Yes, your lordship.
Has their contract has been terminated?
Have been terminated, your lordship.
Is there any arbitration clause?
No, your lordship, I'm not aware.
Just give me the file. Is there any arbitration clause? Huh? No?
I'm not there.
You're the council.
I'm very, on behalf of my senior,
Lordship, since his senior, is out of station, your lordship. They have prayed for the fixing of matter for your lordship.
If there is any stay order, I'm lifting it right now. Is there any stay?
No, your lordship, it's not your lordship.
You're right. On the prayer of the parties, list the matter. On the prayer of the petitioners, list the matter after 2 weeks.
Lordship, if the matter can be fixed, your lordship, since the leading council is from Manipur,
When do you want?
4th of December.
On 4th of December, list the matter. The parties shall also obtain instructions as to whether there is any arbitration clause in the agreement executed between the parties.
Lordship.
Lordship. Lordship, I beg to mention item 8 and 9. My senior Mr. P.B. Ball has some difficulties and is out of station. 8 and 9.
No. Mr. Council, we are adjourning all the matters, no.
Lordship,
Sorry.
Lordship, I don't have to brief also, Lordship.
You may not have the brief, sorry. You can go to Supreme Court or the division bench.
Lordship,
You cannot allow all the matters to be adjourned this way.
Lordship, my senior is
Yes,
not
sorry.
keeping well and he has
Maybe,
had to go for treatment. So,
Maybe.
Lordship, if you can gracious enough, Lordship.
Yes. In item
Kindly, Lordship.
WPC criminal 18, huh? No, sorry,
Lordship, kindly, Lordship. I'm not in a position to make.
I'm sorry.
So then on Thursday, Lordship, then.
Huh?
On Thursday, Lordship.
We'll resist tomorrow. Tell him to come tomorrow. Thursday, we fixed too many.
Lordship.
Mr.
Fuseko.
Poseko, learned counsel for the petitioner, prays for adjournment of this case. Stop. This court is not inclined to grant adjournment. However, in the interest of justice, list the matter tomorrow for final hearing. It is made clear to Mr. Fosiko that the matter will be decided even in the absence of the counsels for the petitioner. Stop. Right. The matter pertains to the challenge made by the petitioner to the promotion of the respondent number 3 to the post of assistant manager from the post of UDA. First up, it is the case of the petitioner that the promotional post of a UDA is head assistant and thereafter a head assistant can be promoted to the post of assistant manager on completing 2 years of service as head assistant. So in the present case, no, the petitioner's case hearing is that the respondent number 3 was promoted illegally to the post of assistant manager from UDA by the respondents having considered the post of the respondent number 3 to be head assistant instead of UDA. What is the matter to me?
Obliged, my lord. My lord, in item number 5, I'm appearing for respondent 8 to 11. Your lordship, my senior's name has not been reflected. If my senior's name may be reflected in the cause list, kindly lordship. My senior's name is
Is there
Limao
item-
Bang.
Yeah,
Yes, lordship. But if
in item 5, you raised, right? Registry to reflect the name of Mr.
Limao Bang
Lima Wapang
for the respondent 8 to
for
11.
the respondent number 8 to 11 in the cause list. Lima Wapang.
Limao Bang, lordships. Hello,
So
Obliged.
tomorrow we're going to do this item 8 and 9.
Hello, Obliged.
For admission, item number 1.
Your lordship, in this matter, I have to file a reply affidavit, your lordship.
No, there's no question of reply affidavit.
Reply affidavit has to file your.
There's no question, Mr. Council, you go to, this is not the proper forum. A disputed questions of fact, this is not a
This,
heard, Mr.
no, your lordship, it's not a disputed question of fact at all, your lordship.
No, you see, Mr. Council.
Yes, your lordship. But I have to file a reply, your lordship.
No, sorry, your prayer for reply rejected.
Your lordship, here.
Now, you see,
Yes, sir.
there are 2 civil cases
Yes, your
in
lordship.
Dimapur.
Yes, your lordship.
You go there.
No, you're there. No, it's not, this property is not related to civil cases, your lordship. This
That
property
is related to that.
it's related to bank guarantee, your lordship. It's related to bank.
Huh?
It's related to bank guarantee, your lordship.
Correct.
Bank guarantee, what I am saying, your lordship, this property, because I have given bank guarantee of this amount, so this property, the total bank guarantee is 4 crores and the total property value is around to 11 crores. I say release one property, your lordship, for the release of the property, your lordship. That's the small issue, your lordship.
You go to the bank, you go to the civil suit.
No, civil suit can't do that, your lordship.
That is the surety.
No,
Your
surety, your
property
lordship, that's
Mr.
the.
Council, please listen.
Yes, sir.
Don't just shout. This is not a fish market. Where you keep on shouting.
I'm sorry.
There's certain decorum you've got to maintain. I can handle you. Don't think that you can just shout and shout.
No, I don't.
Okay, we also can do the same. You want to be aggressive? I can be aggressive.
I'm not aggressive.
I know how to handle you. This is a question of what? This is a question regarding loan
Yes, your lordship.
taken by you,
Yes, your lordship.
taken by respondent petition number 2.
No, it is against bank guarantee, your lordship. Bank guarantee, it's what is happening, your lordship. For OD facility, we give security, your lordship. Security is, we have taken of 4 crores, we have reduced it to, you have reduced to 4 crores, your lordship. Now that 4 crores has to be done, your 4 crores, your lordship. That 4, the property value is 11 crores, your lordship. So the 2 property, I say I want to retain 1 property. The bank is secured by 1 property. 1 property, your lordship. That is what 6 crores. The valuation is there, your lordship.
You have taken a loan, you said. Who has taken the loan?
No, I have
Who has taken you have given the bank guarantee is given by the bank to whom?
No, it is OD facility, your lordship.
Bank guarantee
It's
so
given
what
to the
is-
bank.
Look,
Yes.
look, let us be very clear. Let us be very simple.
Yes, sir.
I'm going to reserve it. I'm going to pass order, whatever it is. So you please give me the facts clearly.
Yes, your lordship.
Yes, tell me.
Your lordship, what has happened, your lordship? The sorry. The initially, your lordship, we have taken, your lordship. We have taken an OD facility.
Who has taken OD facility?
My client, your lordship.
Who is your client? The petitioner number 1 and 2? Or petitioner 1?
Petitioner number 2.
Petitioner number 2
has taken an OD facility.
Is this the OD facility of item 1 and item 2 are same or different?
No, item 2 is different.
Different.
Item 2 is
Has
different.
taken OD facility?
OD facility, your lordship. It is of initial. It was for your lordship. Initially it was 17 crores and 4 crores. 4 crores for credit. OD 4 crores.
Where is the document that showing that you have taken OD facility for 17 crores? Show me.
No, that has been reduced now. That is what I'm saying.
You see, whether it is reduced or not,
Yes.
where is the OD facility that you have taken for 17 crores in the
Yes.
first instance?
Your lordship, see this now. It is annexure P1, your lordship.
Page
21. Your Lordship, see, OD facility is 4 crores and bank guarantee is 17 crores.
Mortgage properties held are surfacey, non-compliant.
Yes. No, then, Your Lordship, we have closed the bank
No,
guarantee.
no, just a minute.
Your Lordship.
You have not given all the documents.
I'll file this document if you give
No,
me.
no, nothing, dude. I'm just, no additional affidavit, no documents required. Whatever is there, we're going to decide on the basis of this. So you have to make your case here. Cash credit facility.
Yes, sir, cascade bank, CC facilities.
So
CC facilities are.
so is cash credit and OD facility the same?
No, your cascade.
So,
Cash-
so cash credit and
cascade-
OD facility is not the same.
Not the same.
So where does it say that you have been given OD facility for 17 crores?
You said bank guarantee, no? Bank is, it's a bank guarantee, no?
Mr. Counsel, you
Bank
had
guarantee,
just said,
If your Lordship see.
you
the-
had just said
Yes.
that you had availed of OD facility. Where is that OD facility?
Your Lordship, right. It is cash credit, CC account, Your Lordship, it is CC account, not cash. I'm sorry, Your Lordship.
Limit is 4 crores.
Yes, Your Lordship.
When was this?
It was, if it was reduced, it was Lordship say subsequent letters, Your Lordship say.
It was, so you took cash credit facility for 17 crores.
17 crores, that has been closed down. That
has been reduced to 4 crores.
No, that is not there. 4 crores has remained.
What do you mean 4 crores has remained?
No, Your Lordship, this.
If 17 crores has been taken.
If your Lordship will see the breakup here, if your Lordship will see page 21, Your Lordship.
Yes.
If your Lordship will see, limit 4 crores is for this cash credit facility. Only cash credit facility they are now.
So
now this bank guarantee is over. We have not. It's not there.
Mr. Counsel, where is the? You see, you're not being clear. You're not being everything is recorded. By the way.
Yes, sir.
All your submissions.
Yeah, I don't.
Now, one thing is, there is no document here showing that you have taken an overdrawn facility for 17 crores.
No, I have not seen.
There is. Just listen. Then even if you have taken a cash credit facility, there is nothing to show that
we have not used it. That's why we closed it. That's why.
You have not.
We have not used it. That's why we closed.
Where is your representation to the bank?
If you Lordship see.
Now, where is this document?
Yes, Lordship.
But these two properties. Where are those two properties?
Property in Dimapur itself, yeah.
No, but where are the documents? Or the property? Where is the document showing that these have been mortgaged to the bank?
There are documents because the letters are there, Your Lordship. These are the valuation reports also there, Your Lordship. Everything is there.
Sorry.
If Your Lordship.
Why should the bank keep your document? There must be some document executed between you and between the petitioner number 1.
Yes.
I think petitioner number 1 is the property owner. Petitioner number 1 and the bank for keeping the property with the bank. Why have you
as security, Your Lordship?
As security for what?
For that facility, Your Lordship.
Which facility?
It is now it has got to that 4 crores CC facility, yourself.
For the 4 crores CC facility, you have given the 2 documents.
No, what has happened? There were earlier, Your Lordship, for this 17 crores and 4 crores, we have got four properties are there.
For 17 crores and 4 crores,
4 properties are given.
17 crores CC or 17 crores OD?
Bank guarantee, bank guarantee, Your Lordship. For bank guarantee facility, BG facility. For BG facility.
For BG facilities,
yes,
for BG facilities,
yes, Your Lordship.
You had given them 2 mortgages.
Yes, sir. No, 4. 2 properties belong.
Where have you said that in your affidavit?
It is there in the petition, Your Lordship. Your Lordship, see para 2, if you look by page 4. The petition number has obtained credit from the Ursel Bank by opening a CC account having a sanction limit of 21 crores. The said credit was approved by a sanction letter so and so dated issued by the Ursel Bank. The total amount credited is divided into 4 crores as CC and 20 crores for the purpose of bank guarantee. Accordingly, the Ursel Bank has issued sanction letter 26 to the petition number by keeping security 4 immovable properties, plant, machinery, and 20% margin. The facility is extended for a year. The said facility was again extended 19 days with CC of rupees 4.
What is CCA?
Cash credit facility, CC. Because I can withdraw that amount for a purpose. The petition number is only a guarantor for the petitioner for the purpose of taking CC and BG facility. Then next area. The petition number has issued letter dated 5/12/2017 to the Ursel Bank and requested for reduction of limit of bank guarantee made available bank by the Ursel respondent bank. The petition number 2 has prayed for the release of property 3 and 4 from the equity out of 4 property taken by the Ursel respondent bank as equity from the petitioner for the purpose of providing CC value of rupees 4 crores.
What is this? What is this property number 3 and 4?
The 3 and 4 that has been released now. That has been bank has released already.
So only 1 and 2 is left.
1 and 2 is there. Out of 4 properties, bank has already released 2 properties because the bank guarantee was closed, that account was closed. So as a result, the 2 properties.
Where have you said that the property number 3 and 4 has been released?
Yeah, if you really prayed for this, the Ursel, I may have proceed further. The Ursel Bank white sanction letter number was pleased to review and renewal the CC and bank guarantee facility. Letter so and so by the CC limit of petition was renewed for 4 crores and the limit of bank guarantee was reduced to 6 crores from 17 crores. This letter is also there. Then the petitioner number 2, besides service charge of renewal and paying 11.5.
Just a minute, just a minute.
Yes, sir.
Yes.
This document is P3 as page 27 here. So the bank document here. This is the reference to the letter regarding the reduction of BG limit and release of 2 numbers of properties out of 4 numbers of properties and mortgage against CC limit bank limit. In this connection, we are pleased to inform you that computer has reviewed the account and approved renewal of reduction of following credit. Renewal of cash credit limit is existing to rupees 4 crores. Reduction of BG limit from 17 crores to rupees 6 crores. Continuous following credit. Commission for professional bank guarantee 0.
No, which para are you reading?
Page 27, document, bank document.
No.
Sorry, I'm sorry. Bank document, page 27 here, Annex P3. Sorry. Annex page 27.
Petitioner number 2, besides the service charge provision, the 2 suits filed by the So these two properties
Yes, Your Lordship.
are security for the CC facility only?
Yes, Your Lordship.
Huh?
Only CC facility.
And what about the bank guarantee?
Bank guarantee, you have closed it. Bank guarantee, we don't
There's
require.
no more bank guarantee.
No, we are not using. We are not using the bank guarantee. Yeah, yeah.
But that is a decision to be taken by the bank. How can we take that decision?
No, Your Lordship, Your Lordship, we here, that has been taken by the bank, because here, that's why the two properties have been released by the bank, Your Lordship.
Correct. But then now you want another one property to
Yes,
be
Your
released.
Lordship, released.
That's all.
That's why one property will remain with the bank out of two.
Correct.
One property that will
So
cover the
let
entire
them-
amount.
Let them take a decision.
Your Lordship. That's, let them take a decision on that, because they are not taking the decision on that, Your Lordship.
So
Because
we direct them to take a decision.
Yes.
That's the matter. We can
Yes.
decide these issues.
that property, because out of properties around 12 crores, and I am not able to let out also. I cannot earn profit on that. Because their bank, if they don't give,
Yes,
and
Mr. Faziko. His cases, he have taken this credit facility.
Yes, sir.
4 lakh, 4 crore.
4 crores.
So actually it was 4 crores and there's 17 crores as BG. Now altogether he had submitted 4 properties as security. Now for the BGs were closed. The bank guarantees, once they became closed, you all did not need 4 properties. So he made a request for release of the property.
No.
2 properties are released. Now his case is that the 2 properties which are still with you as security, the value is 11 crores. We do not know if it's correct or not. But
Valuation
we say
report
that it's around.
No, valuation report is given to the bank.
Whatever, you see, valuation can be done. Actually, it might be only 1 lakh.
No, bank
That
has.
valuation can be
No,
done.
no,
by-
it has submitted bank yours.
The bank has made the valuation.
No, no, we have valuation given.
Correct, but then whether they accept it or not, that's their choice, not yours. I can say that my quote is 20 lakhs worth, but no one will buy it for even 5,000 rupees, like that. So the question is, he's saying that his CC facility, which he's still utilizing, is for 4 crores. And both the properties are worth over 5 crores each. So he says that release one to me. So you take a decision whether it is really, you take a decision whether it's right or wrong. That's all. And then if he's not happy with that, let him go to the civil court, because it's a question of valuation or whatever.
Lordship, my humble opinion.
Yes.
Lordship, the petitioner, that's what I had filed by.
The bank, yes.
The petitioner's alternative remedies before the civil and the bank and civil, under civil and banking laws by approaching the adapted
No,
tribunal.
okay. That's okay.
Moreover, Lordship,
Go to the main issue. Don't go into that alternative remedy for the time being. Tell me, is there some disputed question of fact? Or if that is the case, that's a different issue. But don't go in a general thing. Just see.
total, Lordship, the total amount that was sanctioned to the petitioner is 21 crores.
Oh, wait. Come to para 16, 15. Come to para 15 of your affidavit.
Lordship.
Just read.
May Lordship, that with regard to para 8 of the petition, the inciting deponents denied the same, and in said connection, this is to submit that the allegation regarding illegal encashment of BGs is a subject matter of civil suit. The BG facility closure requires a specific procedure, including extinguishment of contingent liabilities, which has not been complied with. And this is to submit that the rule of law is that once BG invoked, bank is under bounding contract to pay, which was the essential contract, and bank had not illegally encashed the 4 conditional bank guarantee.
So has the bank guarantee been returned to you? Have you returned it to the bank?
Yes, it is there. No, bank, we have closed their everything, your bank. Bank guarantee is with them, it's not with us.
What do you mean? They are the bank. They have issued the bank guarantee.
No,
You have used it.
No, they have encashed it, your bank guarantee has encashed.
What do you mean bank guarantee?
No.
Cash?
this conditional, this,
You see, it's like this. Look, you have probably gone for a tender. Then you are required to submit bank guarantees. Now, the bank guarantees have been made for you by the bank,
Yes,
by
sir.
this bank.
Yes.
Now the question is, have you returned the bank guarantees?
We have closed the account. We have closed the bank guarantee account, BG account. Your Honor. That's why it has come to 4 crores, Your Lordship. That facility, BG facility we have not back. BG facility has been closed down, Your Lordship.
But what about the bank guarantee? Have you given back the bank
Bank guarantee is
guarantee?
with them. It's with them, Your Lordship. Bank guarantee is with them, Your Lordship. Bank guarantee is not.
No. Where-
Lordship, my paragraph 30.
Your Lordship,
Paragraph
bank.
30.
There are civil suits, money suits pending.
That is, see, what has happened here, bank guarantee, they have encashed the bank guarantee.
Who is
And
encashed?
the party for whom the bank guarantee, they have encashed and taken away.
That means you owe the bank then.
No, we have cleared the amount. No.
Bank.
Huh?
Bank, we have paid, we paid that amount to the bank.
You paid the amount.
Yes, sir.
You have paid the BG amount to the
Yes, sir, bank, yes, sir. Otherwise, they will auction the property. If we are not paid, they will auction the property.
So the BG amount.
Yes.
The
Has been
BG
cleared.
was encashed by some other.
Yes,
party.
yes, yes.
And that
Okay.
BG amount has been reimbursed
Yes,
with all the interest.
sir.
Lordship,
Yes.
as per the paragraph 13, there's still money suit 10/2018 and civil suit 14/20 is still pending before the civil court. And as Lordship may come to paragraph 21, page 95, the bit. Paragraph 21, that with regard to the statement made in paragraph 878 and 22 of the petition, the answering deponent denied the same as bank has already released 2 property and BG has also cancelled. And as such, there is only CCA of 4 crores. Further submit hearing that due to pendency of suit at learned court below, as stated above, herein above, an interim order therein, and the interest reversal as per order since 2019, and the accumulation was rupees 2.7 crores approximate, which the petition number 2 had not paid, and as such, no request is tenable at this stage. They're still due, Lord.
Who is Nirmal Kumar Jain?
Nirmal Kumar Jain is the husband of the petition number 1, Your Lordship.
Petition number 1.
Yes, sir.
Who is he? He's the owner of the property.
He's one of the owner. He's owner of one of the property. There are 2 properties. What we are saying that Nirmal Jain property can be retained as mortgage, and petition number 1 property may release here. That is
Nirmal Kumar Jain can be retained.
Retained.
But Nirmal Kumar Jain is not in the thing.
Yeah, Your Lordship, his property is already there with the bank mortgage. Nirmal Kumar Jain he's agreeable for this thing. You know, he's agreeable for. He's not objection to
Just a
this.
minute.
Your Lordship.
So they have said that the value mentioned by you is not binding upon the bank.
Let them make
You
assessment.
go to the civil court.
No, Your Lordship, question is here. They have not objected to my valuation report also. They have.
Heard. Mr. P. Mahavir, learned counsel for you. You can go to the division bench. Heard Mr. P. Chowdhury, learned counsel for the petition. Also heard Mr. Fosico Forte, learned counsel for the
So responded.
sole.
Indian Bank.
Huh?
Indian Bank, the sole respondent.
The petitioner has prayed for a direction to be issued to the respondent bank to release the property of the petitioner located at Patta number 1387, Dag number 26/1665, Golaghat Road, NH-39, Dimapur, Nagaland. measuring 1 bigha 3 katha 14 lechas bracket 25,056 square feet, comma, with single story RCC building from the mortgage taken as security for the cash credit facility provided to the petitioner provided to the petitioner number,
Petition number 2, Your Lordship.
petitioner number 2.
Because he has taken the loan.
But in your prayer, you said petitioner number 1
Which one, Your Lordship?
to the petitioner number 2
Which one, Your Lordship?
by the respondent bank, page 16.
He was issued the recent case in Bajaj and proper.
Pusto.
No, yes, sir. Because property belongs to petition number 1, it's correct, Your Lordship.
Huh?
Property belongs to petition number 1. Petition number is Your Lordship, see.
Cash credit facility has been provided to whom?
2.
Then it should
Yeah,
be
down
provided.
is 2.
So you said CCA facility provided to petition number 1.
CTF of the petition, no, yeah, here. Create charge of property situated in Golaghat so and so.
Don't have to play around.
No, just create charge on the property of.
Right.
So, Your Lordship, what I'm saying, create charge on the.
Anyway, got you. I have clarified.
Yes, sir.
Provided to the petition number 2 by the respondent bank.
It should be, sir, it should petition by petition and not respondent bank, Your Lordship. Say, I have provided a security, Your Lordship. Petition number 1.
The further prayer of the petitioner is to direct the respondent bank to keep the property belonging to Shri Nirmal Jain, being a 7-storied building located at Patta number 40, Dag number 288, Old Daily Market, Dimapur, measuring 0 bigha 1 katha 17 lechas, bracket 5328 square feet, bracket as collateral security. Why collateral?
Bank has kept it for the security. Bank has.
Collateral security
Yes, it's a
for
bank.
the cash credit facility
Yes.
of the petitioner number 2.
Yes.
Then the petitioner has also prayed for a direction to be issued to the respondent bank to close the bank guarantee facility of rupees 6 crores given to the petitioner number 2. Yesterday it has been closed. Given to the petitioner number 2 by the respondent bank. As per the letter dated 24/7/2024, issued by the petitioner number 2 to the respondent bank. Next paragraph. The petitioner's counsel submits that the petitioner number 2, which is a proprietary firm, proprietorship firm, had obtained a cash credit facility from the respondent bank by opening CCA number 501-5399-3251, having a sanctioned limit of rupees 21 crores. The total amount of credit facility was divided into 2 parts. Firstly, cash credit facility was given for rupees, cash credit was given for rupees 4 crores, while 17 crores was to be utilized for the purpose of bank guarantees. Full stop. The bank thereafter issued a sanction letter dated 20/06/2013 to the petitioner number 2 by keeping the 4 immovable properties as security, along with plant, machineries, and 20% margin on it. The said facility was extended from year to year. The petitioner number 1, no, next part, the petitioners councils, the petitioner's further case is that the petitioner number 1 was a guarantor for the petitioner number 2 for the purpose of taking the CCA facility and the BG facility. The petitioner number 2, by letter dated 5/12/2017, requested the bank for reduction of the limit of bank guarantees made available to the petitioner number 2. For the reduction of the limit of the bank guarantees. Petition number 2. The petitioner number 2 further prayed for continuing to maintain the cash credit limit as had been originally sanctioned. The next paragraph, the bank was thereafter pleased to review and renew the CC, the cash credit, and the bank guarantee facilities in response to the petitioner's letter dated 5/4/17, wherein the cash credit was renewed at ₹4 crores and the limit of bank guarantees was reduced to 6 crores from 17 crores. Where is this reduction? In terms of sanction letter number 5/4/2018, issued by the Assistant General Manager of the bank. The respondent bank also released 2 properties out of the 4 properties belonging to the petitioner number 1 and Shri Nirmal Kumar Jain.
No, petition number 2, property, other property, releases petition number 2 property and Nirmal Jain.
No,
If your lordship see, if this property here, your lordship, page 31, if your lordship see.
Come to page 7 of your petition. come to the second last line of your para 7. Why should it be released to petition number 2? Petition number 2 is not the owner of the land.
Sorry, I'm sorry, Your Lordship.
Why are you trying to confuse the court?
I'm sorry.
What are you trying to get out of it? What do I say? And Shri Nirmal Kumar, not and Shri Nirmal Kumar. Next paragraph. As the petitioner number 2 had a dispute with the bank in respect of encashment of the 4 bank guarantees valued at rupees 6,04, 40, 057. On 22/3/2018 in favor of one engineering projects India Limited, comma. Now it has come out.
Your Lordship, I will clarify.
The petitioners wanted to close the BG facility provided by the respondent to the provided to the petition number 2.
Your Lordship, I will clarify one thing here. Your
The
Lordship,
petitioner number 2 filed money suit number 10 of 2018 against the respondent bank for the recovery of the interest charged
that is,
from the respondent, from the petition number 2, which is pending in the court of the senior civil judge, Dimapur. Next paragraph. Yes, what do you want to say?
Your Lordship will see here, because there is a letter also, 3/3/2018, where she has requested for this thing, and bank is, as your Lordship will see, lecture 3/4.
Next paragraph, right. The petitioner's case is thus to the effect that in view of the encashment of the bank guarantees by Engineering Projects India Limited against the bank by the respondent bank, comma, there is a money suit pending in the Dimapur Civil Court. Next paragraph. The petitioners further cases that the market value of the 2 properties which are still held as security by the respondent bank in respect of the CC facility and the encashed bank guarantees should be What have I said?
You just see it as security by the respondent bank and then you put the in case when you
No, is rupees is up is rupees 11,95,62,460. Full stop. The fair market value of the property of the petitioner number 1 is rupees 550,84817, while the fair market value of the property of Shri Nirmal Kumar Jain is rupees 6,44,77,646. Next paragraph. The petitioner's case is that as there has been a request by the petitioners to close the BG facility given to the petitioner number 2 by the bank, the security that is left. No. You have given the bank guarantee.
Yes.
Yeah.
Yes,
Then why is that?
Facility.
Why is the suit? Why is the money suit filed?
No,
against it?
money suit, what has happened? Because money suit is regarding interest charge on that, because there's a different issue. Four condition, I say it's a 4 conditional bank guarantee, it could not be encashed. So for that, the bank has charged interest.
How can you say bank guarantee cannot be encashed?
No,
The very purpose of bank guarantee.
The suits are pending.
Supreme Court.
No, it's a conditional bank guarantee. Under the, it's not unconditional, it's a conditional bank guarantee.
How? There's a conditional bank guarantee.
Yes, sir, conditional bank guarantee. Unless the conditions are fulfilled, the bank guarantee cannot be encashed. So it is on that the interest was claimed. That suit is a different issue. And what is happening, Your Lordship? As a result of this mortgage, I am not able to let out the property, Your Lordship, the building. Because I can earn rent on that. Because the bank has to give NOC. They are not giving, because if you say para 14, Your Lordship.
Just write one more thing. Whatever I said, just read from the beginning. Then around 2 paragraphs earlier. The stand of the petitioner. In the last paragraph. The case of the petitioner in brief. What? Is further to the effect that the petitioner number 2 has paid all the money with regard to the encash bank guarantees to the bank along with interest. Full stop. However, money suit number 10.
Yes, sir.
Of 2018 has been filed against the bank for recovery of
interest.
The interest that had been charged on the bank guarantee, on the encash bank guarantee.
And already been paid.
I know, that's what I also said. Which was as according to the petitioners, according to petition number 2, the conditional bank guarantee had been illegally encashed. Next para. What is the next para?
The petitioner is that as there has been a request by the petitioner to the bank guarantee to be given to the two.
No, cut that. Thus, the petitioner's case is that when the
Your Lordship,
when the business connection between the petitioner number 2 and the respondent bank is only with respect to the cash credit facility of rupees 4 lakhs, 4 crores.
4 crores.
The respondent bank should not be allowed to keep 2 properties as security having a market value of rupees 11 approximately rupees 12 crores. As this was causing loss to the petitioner.
Your Lordship,
Number
say
one.
para 14 here for the petition, Your Lordship has stated there. Page 10. Para 14.
Pustak.
Para 14, page 10.
Pustak. The petitioner's counsel submits that if the property of the petition number one is released, the same can be rented out by the petitioner number one to enable him to earn some money. Pustak. Next problem.
No, may I point it? Here, even if they keep it more, if they give the permission, I can let it out. They have to give NOC so that I can let it out also. That they are not giving.
Okay.
That building here. Because
He
I have stated,
also, he also submits that.
if Your Lordship see para
Yeah,
14.
he also submits that. Even if the respondent bank does not release the property of the petition number one, they can at least issue a non-objection certificate to enable the petition number one
To let out the
to
property.
let out the property
This is the alternate submission.
without disturbing without disturbing the agreement made between the parties, wherein the property is held as security / mortgage for the CC facility provided to the petition number two.
This is an alternate submission, alternative.
I know, whatever.
Otherwise,
Okay, you say in the alternative, huh? In the alternative. Before the sentence, you say in the alternative, the petitioner submit. Next. The counsel for the respondent bank, on the other hand, submits that when there are alternative remedies available under the civil court and the debt recovery tribunal, this court should not entertain the present petition. The respondents counsel further submits that there is no violation of any fundamental rights of the petition. And as such, a writ petition should not be invoked. A writ jurisdiction should not be invoked only to settle a private dispute with regard to money. Yes, what answer have you got to that?
which one, Your Lordship?
This is nothing to do with your rights.
Your Lordship, this is, here you have to, because this lady is not a part, she is only a guarantor, Your Lordship. So, but question is, bank, so long, Your Lordship, so long the bank interest is protected, your bank's interest is protected, Your Lordship.
You're not answering the question. Anyway, you're not answering. I will
Because,
not allow-
why? Because here,
Next.
what, Your Lordship, permit me, Your Lordship.
That no.
Because here, what happened?
No. I asked you a question, you're not answering. You're not answering on the question of
No,
law.
I'm
You're
coming
answering
to the question,
of
Your
fact.
Lordship, permit me, Your Lordship.
Next. You should answer on what I'm, you cannot take a discussion on a tangent, on a different,
No,
when I'm asking
I'm sorry.
something.
I'm sorry, I'm not.
Please, you see, the issue is this. This is not a question of your fundamental right or legal right being violated. This is a question of a private dispute between you and the bank. That's all. Now, whether private dispute should be decided in a writ court.
Your Lordship, so long the petitioner number one is concerned, okay, her property has been taken away, they say, because her property, she is asking for release, because under the law, she can pray for release of the property, Your Lordship.
But
writ-
why should she pray before a writ court?
Writ court can give it,
Why?
Your Lordship, because.
Just
because-
because there's, anyway, I've heard it, okay. We are going to give the same. I know your answer. There's the writ court can go into all issues. That's your answer. Okay, next. The respondent's case is that. The respondent's further case is that. The release of securities is always subject to the bank's satisfaction of ongoing exposure conduct of account and security coverage. Further, the bank had already released two properties of the petitioner number one and Nirmal Kumar Jain, who is not made a party to the present writ petition.
Petition number one is party, Your Lordship. Nirmal Kumar Jain is not party, Your Lordship.
Okay, hearing concluded, judgment is. Next case.
Your Lordship, this side, you can file a here.
No, here also I will.
No, your reply has to file, Your Lordship.
No, no.
Your Lordship.
No,
Because reply is necessary, Your Lordship.
You are rejected. Your
No,
prayer
you
is
please, Your Lordship, Your Lordship, because this, Your Lordship,
your prayer for reply affidavit rejected.
Your Lordship, please, Your Lordship, I'm praying for, Your Lordship. Please, Your Lordship, I'm humbly submitting, Your Lordship. Yeah, I have to file a reply affidavit, otherwise please, Your Lordship, I'm humbly submitting, Your Lordship. Give me some time to
This
file.
is the, you see, para 19 of the affidavit in the position filed by them.
Your Lordship,
Just
please, Your Lordship.
This is,
Your
you
Lordship,
see, this is not a OD facility.
Yeah,
This is a term loan.
Yeah, if Your
taken by
Lordship,
you.
if Your Lordship will kindly.
Heard, Mr. Swenson? Heard.
Your Lordship cannot do like that, Your
You
Lordship.
can go to the.
No, Your Lordship, please, Your Lordship.
You argue this matter now.
No, Your Lordship, please.
Now we'll take it up at 2.
No, Your Lordship,
I have read the file.
No, Your Lordship.
There is no reason to give you.
Your Lordship, give me some time, Your Lordship. Your Lordship, I have humbly pray, Your Lordship.
No.
I have not read the brief, Your Lordship.
You have not read, we'll take it up at 2.
No, Your Lordship, I am not able to do it, Your Lordship. I am not, because I'm not.
We'll read it together. At
Your Lordship, kindly, I humbly submitting, Your Lordship. Your Lordship, give me some time, Your Lordship, to file reply.
Sorry.
Give Samara date, Your Lordship.
Heard, Mr.
No, Your Lordship.
Learned counsel for the petitioner. Also heard Swenson, learned counsel for. Mr. Swenson, learned counsel for the petitioner, submits that he would like to file a reply. And accordingly praise for that. Full stop. I have this just a minute.
Your Lordship, I am humbly praying, Your Lordship. Give me some time, Your Lordship. Your Lordship,
This court, while order dated 11/9/25, had already allowed the petitioner to file affidavit in reply, if so advised. On the last court date, that is on 27/10/25, the matter had been adjourned on the prayer of the counsel for the petition.
let it be the last chance, Your Lordship.
This court has read the contents of the petition and the affidavit in opposition, and is of the view that there is no requirement of filing a reply, and as such, is of the view that the matter should be heard. The petitioner's case has been clearly.
Your Lordship, give me some other date, Your Lordship. I am humbly submitting.
Tomorrow.
Not tomorrow, I am going back, Your Lordship.
Sorry.
I have,
Then you come today.
Your Lordship, I can't do it today itself. Let it some other date, Your Lordship. I am humbly praying, Your Lordship. I have some.
You answer one question. Is this a OD facility or a term loan?
OD facility, Your Lordship.
That only on that ground, I am asking you to go to the civil court.
No, it cannot be civil court, Your Lordship.
Because they have said that this is not.
No, Your Lordship, the documents are there. We are here, Your Lordship. What I am asking you for closure of the account. Closure of the account. Money is there, Your Lordship. Your Lordship, give me some time, Your Lordship. Please, Your Lordship, I am begging Your Lordship. Give some other date. I'll argue the matter, Your Lordship. Give some other date, Your Lordship. Give us some other date.
Why have you come only to ask for?
No, Your Lordship.
You have come from where? Allahabad?
No.
You have come from where?
Delhi.
Delhi?
Yes, sir.
Only to ask for adjournment?
No, Your Lordship, this.
Only to ask for adjournment, you have come to this court?
No,
you could have asked a junior or someone.
No, Your Lordship.
You have only come here to ask for adjournment.
No, I am not.
This is for.
No, Your Lordship, not like that, Your Lordship.
No, and what have you come all the way flying here, everything?
No,
just for
not
adjournment?
here. I did some other matter also. That's why. Your Lordship, kindly accommodate me, Your Lordship. Kindly accommodate me, Your Lordship. Please, Your Lordship. I am humbly praying, Your Lordship.
Is this Is this a OD or a term loan? What is this? Is there a difference between the overdraft facility
Yeah,
and the
then
term loan?
interest is different, interest rate,
Then-
rate of interest.
So they have said that this is a term loan.
Because their letters are there, which I have asked them to convert it. Your Lordship,
You go to the civil.
no, your Lordship, please, your Lordship, give me some time, I'll satisfy it.
No, I'm hearing you now.
Your Lordship, no, I cannot, please,
You
your
can,
Lordship.
then I cannot also. You can go to the division bench.
No, your Lordship, please, your Lordship, I'm praying, give some other date, your Lordship.
I'm giving you time.
No,
Today, you read, you see.
No, today I cannot do it, your
We'll
Lordship.
do it together. We'll
No,
do it
your Lordship,
together.
I cannot do it, your Lordship. I'm humbly praying, your Lordship.
You only come for adjournment. The other case also you came for adjournment.
Your Lordship,
Yeah,
kindly.
you have got clients paying your airfare, everything. And then we thought you have come from Delhi, you wanted to dispose of the matter. So we read the case in advance.
No, your Lordship,
And now, since you have a feeling that the case might not go in your favor, which
No,
probably will not.
I'm not saying anything like that, your Lordship. Your Lordship, give me some other date, yeah, I'll do it, your Lordship, some other date, yeah. In the month of January, I'll come and do it, your Lordship.
No.
Your Lordship, say, I've been just filed a affidavit, I'll do the matter, your Lordship. Kindly, your Lordship, I just humbly praying, your Lordship.
Yeah, submissions are here.
No, your Lordship, kindly give me some time, your Lordship, kindly give me some time.
I'll give you tomorrow.
No,
at
tomorrow
2 o'clock, I'll give 2 o'clock.
No, your Lordship, I have some personal difficulty, your Lordship. Go back, your Lordship. Your Lordship.
Who's that?
I have some personal difficulty, your Lordship. Kindly accommodate me, your Lordship. Kindly, please have it some other.
Hearing concluded, judgment reserved.
No, your Lordship, no, your, it cannot be like that, your Lordship, please.
You see, everything is there. It's a disputed question of fact.
No, it's not a disputed question of fact, your Lordship. No.
You show me.
Your Lordship,
Show me where it's not a disputed
your
question of
Lordship will
fact.
kindly accommodate
You
me.
have said just now that it is an OD facility which you have made. They are saying it is not an OD facility, it's a term loan.
Your Lordship, I have asked for closure of the account, they have
Huh?
not doing. I have asked for closure of the account, they are not doing it.
They're not doing it.
Yes, and they are charging interest on that.
So, okay,
Okay.
then let them take a decision on a representation.
Closure of the.
Let them take a decision on a representation. Is there any writing in writing? they
You have
said-
there, it
Where?
is
Which
there.
page? Which page?
It is there, your Lordship.
Yes, which page?
Your Lordship, see, Annex P18, your Lordship, see, P18. This is there on.
Page?
Page 77. Page 77, your Lordship. I don't require the money, they are not, because they are closing the account, as a result, the interest is running.
So where is their reply to this?
They have not replied, they can pay me, I will give.
End of the matter.
Then if your Lordship will see, your Lordship will see.
So
Yes.
according to you.
Yes, sir.
This page 76 has not been replied by the bank.
Yes.
Not taken a decision on the matter. So we'll close the writ petition, we direct them to take a decision on this letter. That's all. End of the matter. What remains? What remains? Mr. Fasiko, you take a decision on this letter. Page 76. That's all. Heard. Mr. P. Chowdhury. Learned counsel for the petition. Also heard. Mr. Fasiko. Learned counsel for the state respondent, for the respondent bank. The petitioner's case is that the respondent bank had sanctioned and OD loan of rupees 20 crores secured by what? Fixed deposits? What?
FDs, all FDs.
What is the FD? What is the full form?
Fixed deposit receipt, Your Lordship.
Fixed deposit receipt,
Receipts.
bracket FDRs, huh?
In fact, if Your
For the
Lordship.
purpose of opening a mega food park at Dimapur, which was initiated by the Ministry of Food Processing Industries, bracket MFPI, right close, Government of India. The sanctioned OD loan of rupees 20 crores was, however, reduced to 14 crores. The grievance of the petitioner is that the loan had been sanctioned to the petitioner as a term loan. Is it?
Yes, sir.
And not as a OD loan.
Loan against FDs. It's loan against FDs.
Term loan.
Not term loan is different, Your Lordship.
No, no.
Term loan is against property, mortgage property.
Mr. Counsel, this is what you have said in your affidavit.
It's a fully covered secured loan, Your Lordship.
Mr. Counsel, that is what you have said in your affidavit.
No, yeah, that is there. It is a fully secured loan, Your Lordship. That's why it is called that way.
Huh?
It is a fully secured loan because the FDs are much more than the amount, Your Lordship.
Maybe, but then you have said that it is a term loan.
No, term loan, they have said. I say it's not a term loan. I'm not saying it's a term loan, Your Lordship.
No, the respondent, that's what I've said. The respondent bank has sanctioned it as a term loan. They have sanctioned it as a term loan.
Whereas we asked for.
Whereas you asked for, that's all.
Yes.
I've sanctioned it as a term loan. As a term loan by the bank instead of a OD loan. Without the approval of the petitioner. Thereby charging abnormally high interest rates. Though the loan had been covered by the FDRs.
In fact, according to the banks, we have paid excess amount. If Your Lordship, page 84.
No, that's how we'll.
It is bank's letter, Your Lordship.
No. We will,
Around 30 lakhs we have paid excess.
let them take a decision.
No, that is I pointed this also, Your Lordship. Because page 84, if Your Lordship, this is bank's their own letters. Page 84.
Yes.
Your Lordship, see with reference to the subject.
The petitioner. Next paragraph. The petitioner's counsel submit that in view of the above anomaly in the manner of charging interest by the respondent bank, the petitioner had submitted letter dated 27/9/2019 to the Chief Manager of the respondent bank, authorizing him to close the OD loans drawn by the petitioner. He also submits that the respondent bank, by letter dated 1/9/2020, issued by the Chief Manager and addressed to the Assistant General Manager, Zonal Office, Dibrugarh, page 84, had spoken of some technical error. No, spoken of the fact that due to some technical error, the system was charging more than the actual rate of interest as specified in the sanctioned letter. The petitioner's counsel submits that the above clearly goes to show that the respondent bank should have sanctioned the OD loan and not a term loan. He also submits that the letter dated 27/9/2019 issued by the petitioner has not been decided by the respondent bank and no reply to the said letter has been received by them till date. Next up. The counsel for the respondent bank, on the other hand, submit that the writ petition is not maintainable as there are alternative efficacious alternative remedy available for the petitioner who can approach the civil courts or the debt recovery tribunals with regard to his claims, which pertains to questions of facts and banking procedures. It is also the case of the. So, but they've already answered here.
Which one, Your Lordship?
In para 13.
No, Your Lordship, the question they have, well, I asked for close, they have not closed the account. No, I have I asked for closure of the account, they are not doing it. Let them close the account. That is what my.
Have you asked for closure of account in page 76?
Yes, Your Lordship, this is here. If Your Lordship, page 18.
Okay, right.
Page 77.
What have I said? Respondents that the petitioner's request to close the OD loan facility is misplaced as the account is not an OD account. It is a term loan account with fixed repayment obligations. As such, no unilateral closure can be undertaken without full settlement or full payment of total outstanding amount, including applicable interest and charges. Gustav. Next para. The respondent's further case is that the total outstanding amount in the account of the petitioner is rupees 1,78,89,398 as on date, and unless the said amount is paid by the petitioner, no closure proceeding can be undertaken. Gustav. The respondent's counsel further submits that the petitioner's letter seeking closure was duly considered but rejected as the petitioner had yet to fully discharge his liabilities. Its liabilities.
No such rejection letter has come to us, Your Lordship.
These are all questions of fact.
No, they have not sent a letter to us, Your Lordship. But that's why I want to file the reply, Your Lordship.
That's why you go to the civil court.
No, that's why I want to file the reply with point out.
Hearing concluded, judgment rule.
Your Lordship, this page is also important. Page 84, Your Lordship, where they have admitted that they have taken excess amount. Your Lordship, page 84, Your Lordship.
Yes. Yes.
Last one.
from the supplementary cost list for admission item number 14.
My blessed lordship, lordship,
Yes.
here I need a receipt by instruction.
Huh?
I need the receipt by instruction.
No, madam, it's not a question. It's a question of, you see, instruction not required in a way. You have to take a decision as to whether he has been paid or not. Find out whether he has been paid or not. If he has not been paid, pay it. That's all. Come to the thing. Come to the order. Come to the appointment order.
Page 15.
Page 15.
Yes, lordship.
So consequent upon the approval of government also, the interest also, he has been appointed, okay, as printer. Okay. Then he has submitted his joining report on 26/5. So you give his pay from the date he joins. Can it be from the date of appointment or from the date of joining?
Date of joining, lordship.
So you verify and you pay, that's all. Nothing to, you see. And then if you find that he is not eligible to be given, then you give your reasons. Otherwise, waiting for your instructions, madam, will take next year, I
Lordship,
think.
yes, and you have a lordship, if it is in that case, lordship, kindly, pardon, some more time,
Sure. How much time do you want?
6 months, lordship.
Oh, no.
Lordship, it's a lengthy process.
Huh?
It's a lengthy process.
No, this is pay, madam. Has to be done very fast. Christmas is coming. He needs to feed his children. Father Christmas, Santa Claus has to give presents. This is pay. You're working.
Lordship.
You dispose of. You take a decision because you see this. He has submitted his representation on
26/11.
24.
26/11/2024. Yes. No.
So forget your 6 months. 1 year has gone.
Lordship.
And he has not been paid his salary from 23, May 23. So he has not been paid his salary for more than 2 years. This is not done. In fact, he should be hauled up.
Lordship, first the matter will be processed in the department, and then after that,
I don't know.
for authentication, it will be submitted before the finance. After that, only the petitioner will get the salaries.
Let us see if you have made the finance department a party. Good. Your department also, you have made them a party, no? You'll have to file a contempt most probably, I think.
Lordship.
Heard, Mr.
Subhamati.
Supamvati, learned counsel for the petitioner, and Miss
Pichano.
Pichano, learned GA for the state respondent.
Understand?
Puस्तक. The petitioner's case is that he has been appointed as Pharaoh printer on compassionate ground by office order dated 24/5/2023 issued by the engineer in chief PWD Nagaland. In terms of the government approval issued by letter number WH/EST/47/06 bracket PT-Roman 2 bracket close dated 17/5/2023. This is in page 15. In the pay level -2 bracket 16/100-50/900. The petitioner joined his post on (26/11/24). However, the petitioner has not been paid his salary till today. The petitioner has also submitted a representation. No, 26, joined the post, no.
Lordship,
Joined this post on
26.
26/5/23, okay. The petitioner's representation dated 26/11/2024 for payment of his salary has not been decided by the respondent authorities still. This court is of the view that the actions of the respondents does not appear to be fair. As such, this court directs who is the main person to do it? Who is the controlling officer basically? You are where? You are
Respondent 5, Lordship.
accordingly, the respondent number 5. Accordingly, according to the respondent number 5 shall immediately send what? Accordingly, the respondents number 3, 4, and 5 are directed to pay the petitioner his salary from 26/5/23 in terms of the petitioner's appointment while office order dated 24/5/2023. Within a period of
Lordship, that 4 months.
within a period of within a period of this what it
Lordship, 2 months, Lordship. This is my only livelihood.
Yes, Lordship.
within a period of 2 months, the periods of 2 months from the date of receipt of a copy of this order. The writ petition accordingly disposal. Acha, you said before that say, come on. If not ineligible on some other ground. The writ petition accordingly disposed.
Thank you, Lordship.
Obliged, Lord. For hearing, item number 15. Cool.
Glasses. Cool. Lordship. Lordship, if you can go straight to the law so that we can shorten the matter. So the Nagaland Code, Volume 1. Nagaland Code, Volume 1. And if your Lordship can turn to page 437. 437.
What is this law? This is
list of central acts in force in erstwhile Naga Hills, Twensang area immediately before 1st December 1963.
Okay.
Yes.
Page 437.
Yes, 427.
27.
427. This is the part under which the relevant law, which I'm going to refer to your Lordship, is, your Lordship. So this is part 7 of the Nagaland Code, Volume 1, beginning from page 427. Now, if your Lordship will turn to page 430. Yes, my Lord.
Yes.
The first act at the top of the page, 1869, the Indian Divorce Act, 1869, and applies to the entire state
on the right hand, the column number 4. At that time, it was just Kohima and Gokchung. So it applies to the entire state. And Twensang. So it applies to the entire state. Then on the right hand column, Your Lordship, also in the right.
Are we agreed? Are we agreed to that?
That is the state act.
So I just wanted to know, are you disputing this?
No, Your Lordship, I'm not disputing that.
Okay.
I'm not disputing.
Then the next one on the next page, at the first entry, 1872, the Indian Christian Marriage Act, 1872. Again enforced in the whole state. Now, if you can go to page 493, which is the State of Nagaland Act 1962.
493,
493.
page 493.
Yes, madam. Is the State of Nagaland Act of 1962.
493. Yes.
And if you can go to section 26 now, madam. Section 26. Which is at page 502.
Yes.
May I read, my lord? Section 26, part 6, section 26. Your Lordship, in the middle of the page.
502.
Page 502, yes. In the middle of the page, on the part 6. Has Your Lordship got it?
Yeah.
Yes, section 26. Continuance of existing laws and their adaptation.
Yes. Yes.
All laws in force immediately before the appointed day in the Naga Hills, Twensang area shall continue to be in force in the state of Nagaland until altered, repealed, or amended by a competent legislature or other competent authority. So, no change, still applies. So the Indian Divorce Act of 1869 still applies, indisputably, Your Lordship. Now, on the Indian Divorce Act of 1869, there is already a decided case arising from the state of Nagaland. And Your Lordship will find that in 1986, if you can go to that straight away, Your Lordship, 1986, 2 GLT at page 296. I have the list of, in fact, Your Lordship, I've called out the authorities. Is it already if we just go through the principles? List of authorities. So this is between a husband and wife from the state of Nagaland. And there are no paragraph numbers, Your Lordship, so I've just called out the principle. The Indian Divorce Act 1869 is applicable to the state of Nagaland. When the parties are unwilling, the court cannot compel the parties to go to the panchayat. In the instant case, the petitioner has never been subject to the jurisdiction of the Dunki Village Council. As such, she cannot be compelled to submit to this jurisdiction and abide by the order passed by the said council. Also, the order of the village council is without jurisdiction and non-est in law.
Why do you say this order of village council is without jurisdiction and non-est in law?
I'm coming to that. The second point, then if you can go through this judgment, Your Lordship. If you can go through this judgment.
Yes.
Which one? Same thing, no? Oh, yeah, this is better. Can we turn to page 297, Your Lordship? 297. Just the brief facts in the first few paragraphs.
Yes.
This revision petition raises a question of law of general importance and of general interest and considerable importance. The question is whether the Indian Divorce Act 1869, hereinafter referred to the Act, is operative in the state of Nagaland. The respondent, Srimati so-and-so, and her husband, the petitioner so-and-so, are Christians. They are Naga tribals. They are residents of the state of Nagaland. The respondent wife filed a suit seeking divorce under Section 10 of the Act before the Additional Deputy Commissioner, Judicial, Dimapur, Nagaland, on the main ground, amongst others, adultery coupled with cruelty by her husband. The husband opposed the petition challenging the jurisdiction of the court to try a divorce suit on the ground that the act was inoperative in the state of Nagaland. The question had been raised both in the High Court and the Supreme Court, but the Supreme Court, without expressing any opinion on the question of jurisdiction, as the question arose out of an order passed in the interlocutory application, directed the Deputy Commissioner to dispose of the suit finally within 4 weeks from the date of receipt of the order. The additional Deputy Commissioner heard the learned counsel for the parties on the question of jurisdiction and held that the act was applicable to the state of Nagaland. Aggrieved against the said decision of the additional Deputy Commissioner, this revision petition has been filed under Rule 34 of the Rules for the Administration of Justice and Police in Nagaland. So the next question is, whether the next paragraph, the question is whether the Indian Divorce Act 1869 is applicable to the state of Nagaland. Then there's the discussion which follows, Your Lordship.
Yes.
Discussion which follows, and then page 304. The argument which was submitted before the Honorable Court is page 304.
Yes.
Yeah. On the submission of the Learned Council is that one other submission of the Learned Council is that by virtue of clause 1 of Article 372 of the Constitution, it should be 371A, basically, but you mistake in the article number. The customary laws of Nagaland relating to marriage and divorce prior to the commencement of the Constitution continue to be in force after the commencement of the Constitution until altered or repealed, and therefore the Indian Divorce Act is inapplicable to the state of Nagaland. But clause 2 of Article 372 of the Constitution of India empowered the President to make by order such adaptations of such law, whether by way of repeal or amendment, as may be necessary or expedient for the purpose of bringing the provisions of such law into accord with the provisions of the Constitution, and to provide that the law shall, as from such date as may be specified in the order, have effect subject to the adaptations and modifications so made. In exercise of the said power, and the President made the adaptation order dated 1950, which came into force on 26th day of January 1950. After adaptation, Section 2 of the Indian Divorce Act reads as follows. That is the recital of the adaptation. Then the second last paragraph, Your Lordship. Second last. The state of Nagaland is a part of India. Therefore, there is no escape from the conclusion that the act is also applicable to the state of Nagaland. Then, in the next page, at page 305, Your Lordship. In the middle of the page, Lordship, the contention of the Learned Council, has the Lordship got that? In the middle of the page? The contention of the Learned Council, relying upon the provisions of Article 371A of the Constitution, providing that no act of Parliament in respect of Naga customary law and procedure shall apply to the state of Nagaland, unless the Legislative Assembly of Nagaland by a resolution so decided, need not detain us long in view of the express provisions of Section 26 of the State of Nagaland Act 1962, which I was referring to earlier, Your Lordship. And the further fact that the Indian Divorce Act 1962 is not an act of Parliament to which the provisions of Article 371A of the Constitution are attractive. So the argument of Article 371A was repelled. And one of the reasons for repelling the argument, Your Lordship, is that the Indian Divorce Act of 1869 was already in force, and Section 26 says that it will continue to be in force unless repealed, etc., etc. Never been done. So 1869 Act is still in force. Now, interestingly, Your Lordship, there's another case, and this is now 2022, 5 GLT at 392. Now, this is a case about the Armstrong Changsan case. Your Lordship is already aware of this case. The Armstrong Changsan case, the cookie gentleman in the Indian Foreign Service who got his divorce from the tribal council, the village council. The matter went up to the Learned High Court. This Honorable Court in the single bench held that where the Indian Divorce Act applies, there is no question of going to the village council. That is an act without jurisdiction. That is why I was saying it is without jurisdiction. The matter went up to the Supreme Court. The Supreme Court refused to interfere. The only ground the Supreme Court case the appeal pending was there was some efforts at a settlement. That is why the matter was kept pending. Otherwise, the decision of this Honorable Court that where the Indian Divorce Act applies, divorce can only be decided by the authorities contemplated by the Indian Divorce Act. That is district judge.
But there is one thing.
Yes, ma'am.
Was the marriage done under the Indian Christian Marriage Act?
Your Lordship, Christian marriage. Christian marriage.
See, the Indian Divorce Act
Yes.
would apply when a marriage is done under the Indian Christian Marriage Act.
No, Indian marriage, Your Lordship, Indian Christian Marriage Act is just about Christians getting married in accordance with Christian practices.
Correct. Correct.
There's no requirement of any registration of any sort. So this was a church marriage. This was a church marriage. This was a marriage solemnized according to Christian principles. So therefore, the Christian Marriage Act applies. And as Christians who got married in church through the church practices, their marriage is governed by the Indian Divorce Act of 1860.
No, you see, the question is this. If the marriage was in the church, that is not a customary law. That is not a custom of the
Yes.
matters.
Yes.
Now, to have a valid marriage, it has to have some legal sanction.
Yes.
Now, if the marriage is not as per the customs, the Naga customs,
Yes.
it is not a valid marriage.
Yes.
So if there is no valid marriage, where's the question of divorce?
No, Your Lordship, even in these cases, the Nagaland case, as well as the Armstrong case, it was all marriage in church.
No. I believe there was a marriage I think there was a marriage done by the marriage officer that has been delegated the powers under the Indian Christian Marriage Act. You see, you've got to be very careful. We cannot jump to conclusions. Otherwise, the marriage had been done because they were married in Assam.
Yes, Your Lordship.
Aflong.
Yes, Your Lordship.
Somewhere like that. There, the marriage was done as per the Indian Christian Marriage Act by a marriage officer duly appointed by the government.
In our case,
In your case, there is no such thing.
there is no such practice here.
So now the question is,
Yes,
I'm not on the issue of divorce right now.
Yes, Your Lordship.
I'm on the issue of marriage. My first question to you is whether your marriage was legally valid.
This
is a very dangerous
Yes, Your Lordship.
territory we are going into.
Yes.
But you see, now because you see, unless there is a marriage, if there is no legal sanction to the marriage that occurred between you and your wife, where is the question of divorce?
Your Lordship, in the case of Nagaland, even in this Nagaland case, there is no marriage officer before whom the marriage is registered.
That is what. So, if there is no marriage, where is the question of divorce?
And if we can go to the Armstrong case,
This
has
to be dealt, I think, quite delicately.
Yes, Your Lordship.
This case. It's not so simple as you all think. You want a divorce?
Yes, Your Lordship.
Where is the need for divorce? You're not legally married.
Can we go to the provisions of the Indian Divorce Act then, Your Lordship, for a moment?
For a divorce, you need a marriage first, no?
Very well, Your Lordship.
Show me the marriage.
Yes, can we go to the
Yeah,
provisions
yeah.
of the Indian Divorce Act? (1869). Can we for a moment go to the Armstrong case, Your Lordship? Just for the recital of facts. In the meantime, I thought I had the copy of the Indian Divorce Act. It's not on my file.
No, you see, whether we go to Armstrong, what do you want to show in the Armstrong case?
No registration.
Okay, so no marriage.
No, but the thing.
No, registration is not a sine qua non for proving that there has been a valid marriage.
Yes, Your Lordship.
It's only after that. I think the marriage. Now let's talk about marriage in general.
No, what happens is, if I may, Your Lordship, what happens is in Christian marriages, what they usually do is they get married according to Christian rituals. Subsequently, to prove their status as husband and wife for the purposes of going abroad, they have to produce a marriage certificate, which they register. That's a subsequent act. That's a subsequent act. And your lordship will see the Armstrong, even in the Armstrong case, the only point taken into consideration is marriage according to Christian rituals. That's all.
No, agreed. Because no one put the question to anybody, neither to the court or to the parties, as to whether the marriage was legally valid.
A Christian marriage is valid, your lordship.
In Armstrong's case, in Assam,
Yes, your lordship.
there is a marriage officer. You see, as per the Indian Christian Marriage Act, if I'm not mistaken, there is a provision where only certain persons can perform the marriage ceremony.
Your lordship.
So those persons are the ones who have been given authority by the government under some provision, some section 24 or I don't know, some section.
Yes, your lordship.
Only those persons can perform a marriage.
No, sure.
Now, that issue of whether there was a valid marriage or not a valid marriage, that was not an issue there in Armstrong's case. There was straight away the court took the plea, and they also took the plea that they had a valid marriage. So the question of the validity of the marriage was not an issue.
Your lordship.
So what I'm trying to say here is to decide a question of whether there should be a divorce or not, or whether a person can, whether the village council can divorce a person or not. First, the sanctity of the marriage has to be proven. Whether there was a valid legal marriage. So, marriage can be done as per your customary law,
Yes, your lordship.
as per your customs,
Yes, your lordship.
or it can be done by the Christian.
But your
Marriage
lordship,
Act,
even in the
or
case of,
Christian Marriage Act.
your lordship, even in the case of, for example, even in the case of Hindu marriages, there's no question of registration.
No, I'm not talking about registration. Registration, forget it.
Yes, your
I'm
lordship.
not in registration. I am on the ritual
Yes, your
itself. I'm on the ritual. The ritual being under the Indian Christian Marriage Act, the marriage has to be performed by a duly authorized officer by the government. That means certificate has to be, an order has to be issued. Under so and so section, you are, give us the Indian Christian Marriage Act. Do you have it here? It is there that only those persons can perform. Now, what is happening is our church pastors are, it's happening in Mizoram also.
Yes, yes. It's happening everywhere. Yes.
So people are not questioning. But if you are in a court of law, now when you are going to decide questions of law, these questions will start to come up. Whether a pastor is performing his marriage under the Indian Christian Marriage Act or under the Christianity ritual being practiced in that particular state.
Yes.
Okay.
Yes.
Now, that does not have any legal sanction in terms of the Indian Christian Marriage Act unless he has been given authorization by the government or under the custom or the customary law, because there is not a custom. So 371A will not be applied.
No reply.
So that is what I'm saying. A divorce will only happen if there is a legally valid marriage. So, I mean, I do not know. I might be digressing also, I don't know. But I think when deciding this matter, we'll have to be very careful. Because we might be impliedly saying that all marriages are illegal. You see, what has been done in Mizoram now? Mizoram, always the custom has been followed. That means the paying of the bride price and the disbursement of the bride price to the bride's family. And then after they have the marriage in church. So at least the bride price, that part is protected under Article 371G for Mizoram. Though the marriage might not be in terms of the Indian Christian Marriage Act in the church. So in 2014, they made a law there. Marriage Act is there, 2000 Marriage, Divorce and so Act, whereby they've incorporated both the rituals. Anyway, in your case, there is none right now.
In the state, no, Your Lordship. In the state. In fact, all the marriages in the state are performed by pastors.
So, in a way, if you're never married, so So why are you coming to court? Yeah, you get my point. Look,
that is true.
if you are never married, then no divorce is necessary because you are never married. Only problem is
And
that
then-
the repercussions
and then-
are such, children, family, so much. So this case should have to be done very delicately. And we have to.
If we,
have to be
I understand that, Your Lordship, but if we go by that line, it would mean all the marriages in the state of Nagaland are null and void.
But you think of it as a lawyer. Just think of, forget, don't think of it as a, supposing you are a lawyer from mainland India, you are not a Naga, you are born somewhere else. And supposing this question came to you, what would you say?
And then again, Your Lordship, there's another issue which is also connected to this. Your Lordship will recall, directions have been given by the Honorable Supreme Court that in places where marriages are practiced according to customs and practices, all marriages would have to be registered. That direction was issued. So therefore, if the Indian Christian Marriage Act was strictly followed, they would have had to be registered. But since it was not followed, the Supreme Court says all marriages, they would have to be,
No, all marriages
would have to be
as
registered.
long as we accept it's a marriage.
Yes.
It has to be, that's the subsequent thing. It's not
Yes.
part of the custom. It's a new feel altogether.
Yes.
Now, the only problem here is that once people start questioning the marriage itself, then what to do? But now, my question is there a legally valid marriage between you and him? Because your answer is simple. Your answer is also simple. There is. So both of you are accepting that there is a valid marriage.
Yes.
But under what law? Now, if your marriage was under the customary law, custom should prevail. In a way. Though there is the Indian Divorce Act.
Yes.
But custom should, because marriage is done under that. So if it was done under the Christian Marriage Act, then the Indian Divorce Act could prevail. But yours have been done under neither.
And then again, there's the Family Courts Act. All marital disputes have to be before the family courts now. So what is to be done, Your Lordship?
I don't know, you tell me. I'm just bringing up this question.
In any way you look at it, Your Lordship, the village council has no jurisdiction. Village council has no jurisdiction.
Correct. Because you see, village council, your marriage is not under the customary law.
Because it is, among the Nagas, it is customary.
No. Christianity, you see, what is the custom? What is the custom? What is the definition of a custom? A custom is something which has occurred from time immemorial. And it is the constant practice till today.
Yeah.
Not only that, the third ingredient is required, that it should be given the force of law. That means it has to be accepted by the court as a custom to become customary law. All customs are not customary law, mind you. While all customary laws have origins in the custom. So, in your case, for a village council to say that no, you are going to be divorced or not divorced under the customary law would only apply when there is a marriage under the customary act.
There is no such act.
Customary law, not act, I mean customary law, under the customary. There is no customary law. So why should they have any say whether they are married or not?
Yes, Your Lordship, there are these issues unless certain legislation is done. But here in this case, normally the Nagas they marry, and when disagreement occurs, the families come together. If they have to live together, they live together. If they have to part ways, they part ways. And as per the customary law, who gets what is determined.
And now
That is all.
You're the husband.
I'm the husband.
And what did the council say, village council?
The village council.
That they should live
After
together.
Yes,
or what?
after the law, if one party deserts, if one
Oh,
party
yeah, okay.
refuses to live, then it is cannot.
It is.
It comes to an end. So here in this case, The wife left the marital home with all the movable property. And then refused to even reconcile.
And according to him,
Yes.
you left.
Yes.
No, initially, before the divorce, because of the dispute in the family, I didn't want that kind of situation at home, so I went and stayed with my parents, but the wife remained in the marital home. Wife was remaining there. Now reconciliation process started with the agreement of the two families. Since the pastor who solemnized the wedding, both the parties' parents agreed to entrust him and one witness who was there at the wedding. The pastor and the witness tried their best, but the husband's family informed the pastor and the witness to the network that everything is now on your
Now,
What happened was the wife and her family refused to reconcile. They didn't even pick up the calls after the initial call. So what happened? They gave up. Now the petitioner, the respondent, the husband had to move on. He cannot live like that. So he said, all right, if that is the case, she has taken everything again. And even before the actual divorce, the wife filed for custody of the child. So now it became irreconcilable. There was no way out. And the husband could not remain like that. So he decided, all right, since I belong to this village and since as per custom, whoever is the wife, she also automatically becomes the tribe as well as the member of that village. I will ask the village council to do the next one. What happened was the village council said, yes, the wife is deserted with all properties. So now automatically the marriage has come to an end. That is as simple as that, you know. It has come to an end. Now based on that, I decided to get married again. Cards came out. And when she got wind of the
Even the second marriage, Your Lordship, is not a valid marriage then.
yes, she filed this petition challenging after so many months. Now the petitioner and the husband have again got married.
And then there's another
Now,
aspect,
if
Your
this
Lordship.
court should
Another aspect, Your
interpret
Lordship.
this decision,
The family court has passed orders of custody.
just a minute. No. I think I've lost sight of the main issue. What is the main issue? The facts?
The village council has got no jurisdiction to dissolve my marriage. That's
Dissolve
the
your
issue.
marriage. So you want to remain married?
No, I have filed a divorce petition in the family court.
Okay. You have filed a divorce petition
In the family court. Yes.
And that is?
It's still pending. It is still pending, where the other side has entered appearance.
When did you file?
simultaneously with this petition in the month of November 2024.
2025.
2024. November 2024.
Firstly, Your Lordship, I filed custody case 12 of 2023 in the family court. 12 of 2023. After I was deserted by the respondent. Custody case 12 of 2023.
For the kids?
Yes, for a kid.
Why he had taken them or what?
The elder kid. Younger kid was with me. Elder kid had been taken. Then that order, the respondent was aggrieved by that order. He came before his honorable court. Some orders, directions were given to the family court to decide. And the family court decided by an order dated 19/3/2024, where visitation rights was also given to him.
Okay.
Now, he took advantage of that visitation right as far as the older daughter was concerned. He found that the daughter did not want to stay with him. So he returned the daughter to me, and since then, he has not bothered to take any sort of custody as far as the children are concerned.
Okay,
Then we filed divorce petition. We filed a divorce petition.
In
the
November
family court.
24.
Yes, Your Lordship. in 2024. And then he filed an application to the village council on 22/2/2024, after the orders of the custody, after the orders of the family.
divorce
Yes.
in the family court.
Yes.
No, Your Lordship, no. The family court divorce petition was filed.
No, 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 I'm talking about custody case.
Yes, that
Custody case.
under the guardian. and
Divorce case filed when?
November of 2024, Your Lordship.
November of 2024 filed.
Yes.
When did you go to the village council order is passed on?
February of 2024. And the order was passed
No, when will be filed?
on 16th of April, 2020.
No, it
24.
should-
Then, only after the petitioner decided to get married and the cards came out, he got wind of it and immediately approached his court and also.
Not November, Your Lordship.
simultaneously
We filed
the
in the month of,
divorce petition.
we filed in the month of March 2024. No, in the month of. No, this was by. When did we file those? I'll give you the date, Manad.
Your Lordship, it is page 101 of my affidavit in opposition. This is the notice which was issued on 12th
Where's my petition?
November 2024.
So you are married now?
Yes. He was to get married in December.
Okay,
5th.
so what is the fight all about now? The money?
No,
Now
we've
we have
just,
filed several
no,
applications.
no, Your Lordship,
What is the issue? What do you want?
we want a divorce. We want to be separate now, Your Lordship. Even during the time that we were married, he was already having affairs.
So, no, so, okay, supposing we say that, okay, that is now the divorce is granted. What do you want out of the divorce? Nothing.
We have filed a maintenance petition also, Your Lordship. We have filed custody petition. Those are all pending.
Look, I think you can have a settlement. I think this is a fit case for,
We have tried. We have tried mediation, Your Lordship.
okay,
Mediation failed.
In the mediation, our stand is was that it should be done as per the customary. Because the customary law is there, it has to.
no, forget ego, forget about customary law of, what does she want from you? Some
She
monetary
is
thing?
seeking maintenance. There are two applications involving maintenance. One under the Domestic Violence Act.
Domestic Violence Act,
Under the
right?
Domestic Violence Act, maintenance order for maintenance was passed, amounting to 2 lakhs initially.
2 lakhs
And then
per, 2
subsequently-
lakhs per year.
Month, Your Lordship. And then it was again.
Reduced to 60,000.
Reduced to 60,000.
It is,
Again,
which they have not complied with till today.
again, we filed an appeal, but the appeal was that the council who represented me in the original court, and the appellate, before the appellate court, he filed it under Article 371A.
Yes.
So it was withdrawn and then to file,
You can find a fresh. what
yes,
is it?
afresh also. So that is going on. In the meantime, again, they have filed again maintenance.
No,
application.
that is there from before.
So anyway, that maintenance can be clubbed into one issue.
Yes.
That is not an issue. You see, there cannot be two separate maintenance. One is for the children and one is for her probably. So how much are you willing to give?
Your Lordship,
Nothing.
I am
Nothing.
unemployed, actually.
Father is minister or
But
something?
no.
Your father is a retired IAS officer.
I am
Retired.
dependent on my
He
father.
he
That
has-
does not mean that
And
my father's pensions belong to me. It's not like
correct.
that.
The
And
son,
they are.
not unemployed, class 1 contractor. He owns a boutique hotel in Dimapur. He's got plenty of properties in and around Dimapur and Kohima. All false statements, Your Lordship.
The father.
They don't want to give,
father wants-
they don't want to give the petitioner anything. They say in accordance with custom, you are not entitled to anything.
oh, okay.
That's the whole issue, Your Lordship. And in fact, in a mediation
So
proceeding,
you have to give something.
Yes, so far as the maintenance is concerned, it should be reasonable.
Are you giving anything till now?
nothing.
No.
Not even honoring the court's orders, Your Lordship.
Because
nothing.
we have filed an appeal.
No, there's no
They
appeal.
should withdraw.
Wait,
They have
No
also
appeal.
filed their appeal against the maintenance.
maybe, but the last order passed by the last competent court is the order that is right now valid. You've got to comply.
Your Lordship, we have filed an appeal and then because of those issues.
No.
those
There's no
complications
appeal as
because-
far as the
But so
respondent
far-
side is concerned.
Maintenance is concerned.
Can
it's stable.
you bring them tomorrow? You bring them day after or tomorrow, day after. I'll talk to them.
No, but that is one side, Your Lordship. But what about the village council's order?
Then we'll decide, once we see this, then we can, there can be some sort of some order can be made out. We'll set it aside or something in view of the settlement bid. You come, you make a proposal, how much, so you have got 60,000 per month.
Nothing.
No, but then,
Yes.
That is the subsisting order, Your Lordship.
so you're okay with that?
I have appealed against that order.
He's not okay with that.
I have appealed
They
against,
want in terms of lakhs and crores. Your Lordship.
which they agreed initially,
No.
which they agreed, he doesn't know,
Look,
But-
I'll tell you what.
but
I'll tell you what can be done is, instead of this monthly business, forget it. Have a one-time payment. Few lakhs here and there. You'll decide. And how much is your client willing to?
I'll have to discuss that with her, Your Lordship.
I think that's the best. There's no point. Otherwise, if you do it monthly, after a few years, it'll go. How old are the kids?
One is five, must be five now. The
And,
other will be around 1 or 2 by now.
Still minors, you know.
Yes, still minors.
Then you're going to have another family there with the latest.
Yes.
Your Lordship, is,
Yes.
I have been
Blessed.
placed in
You've
that
been blessed.
position.
Placed. Oh, you mean placed?
Even
I
if-
thought already
even-
blessed.
Even with the second wife, I have a son. Only
Oh,
recently
that's
born.
what I'm saying.
Yeah.
Already blessed.
Your Lordship, if I may, the only thing which is standing between the parties for a settlement, as far as I know, is the village council's order, which says, I am not entitled to anything.
No. That it cannot stand.
Your Lordship, I have not even pursued for recovery of all those movables.
No.
I only wanted a declaration that it has been annulled. It is now, the marriage is gone.
No, you
But-
cannot leave your wife and children in penury. That too, this court will not allow.
Yes, Your Lordship, I have clearly stated here that all the movables, more than 2 crores worth she has taken. 2 crores worth.
Which I've denied.
They may deny, but I have listed out. the
In
inventory
fact,
here, clearly.
in fact, what he's asking for,
How much money has she taken? How much money has she taken in your inventory?
And then some rents which actually should go to my father. That rent also she collected and few lakhs, Your Lordship, I have made specific statements here in paragraph at page 11.
No, just tell me how much money has she taken? How much money? You see, the thing
She has
is,
taken around-
the thing is that there's no point.
Yes.
Your cases is not going to end, the way I see it.
She has also.
Unless, you
Yes.
see, because if I decide this, one of you is going to the higher court and going to jail. Unless all the things are hashed out together, you are not going to leave each other.
Your
So
Lordship,
I think my view, subject to correction is, if you can come to a figure that you're comfortable with,
Yes.
and if you can ask to help you a little bit and come to try and match the figure. If not the whole amount, at least to a certain extent. Because I'm quite sure both of you now will start thinking of, okay, bargaining with the actual, but bargaining chip will leave this much. So without that bargaining part. I think maybe that should be tried. Are you willing to?
I am willing, even
No.
before.
No. That's a absolutely wrong statement.
I'll call both of you all
Yes, Your Lordship.
Yes,
in person. Let them come. And I will talk to them with Madam Longpumar. Maybe without you all, if you all want to be there.
No,
also
without
go.
us, it's better.
without us it will be better,
So we'll talk to them
yes.
and we'll tell them, but you also impress upon your client
I'll do
that the leaving them penniless, that order will probably go.
Your
So,
Lordship, yes, during the council who is representing.
so can they come tomorrow, day after? Because I've got only 3 days left.
I don't know if it would be possible, Your Lordship. I'll go and make an endeavor. Yes,
Otherwise,
absolutely.
what you can do is, you can talk to them today, both of you. Give me a figure by tomorrow. Give me a figure by tomorrow that you are comfortable with and you are comfortable with. And then because yours is going to be high, he's going to be very low straight away. That is 100% guaranteed.
Your Lordship.
But then at least you all will know how much the other one is comfortable with. And you all can think about it, then we can call them on a Friday if you want.
I have no objection, I have no.
Friday.
Otherwise, you can do it next week also with other judges. I'm going to be here till Friday only. That's why I'm saying. Otherwise, you see, best is to thrash out all the issues at one. If you can come to one solid figure instead of monthly maintenance. Monthly
No,
maintenance
my
will be a problem.
Your Lordship, I have this apprehension that within this 1 or 2 days, it may not be possible for these two to work things out.
Okay.
In my case, I believe I can.
No.
Then you have not paid your maintenance till now, no?
No.
From which month? From which month?
From the very beginning
Which
of
is
the
the-
time that he deserted
When
us.
is the?
The initial order was passed in April.
April?
April of 2024.
2024.
Yes, and then we went on appeal and it came back again.
So
and
how much
again.
monthly maintenance are you willing to give? Right now?
That amount I cannot say.
No, that amount you will have to say. Otherwise, I'll have to order you to pay.
Your Lordship, I'll talk to them. I'll talk to them because the income fluctuates from year to year because he is not a regular government employee. His father is a class 1 contractor. Now what happens is that.
So you give me a figure.
Yes,
You give me
so
a figure.
I can.
Okay, we'll list it when? Day after tomorrow.
Your Lordship.
You know, because you see, if I did this for finishing this case, the problem is that this has to be dealt with slightly delicately. I'm dealing in principal seat. I'm dealing in this criminal matters and this family matter. DB. And it's very difficult to decide a matter unless you decide the core issue of money. Once this money issue there, it becomes slightly easy to do things. So I'm just trying to find out a common ground if you can come to this, because then it becomes easier. Because if I pass this order, either which way, one of you is going to take it up. It's not going to end there. Plus his appeal, and then your appeal is also going to come. So but at the same time, you cannot run away from your liability, your monthly liability. You have to pay. The kids are there, the wife is there.
Yes, only that because of the exorbitant amount that was granted, I am unable to pay that amount on monthly basis. Because of that, appeal was preferred, but under a wrong provision of law, only recently it has been withdrawn.
No, it's been quite some time.
Yes.
It's been quite some time that they withdrew.
It's about a month now.
And no appeal has been filed.
Yes,
And
but they have filed against.
How much are you willing to pay?
I will talk to the
Otherwise, you deposit 7 lakhs.
I'll talk to
You
the,
deposit 7 lakhs. You tell your client to deposit 7 lakhs.
as a final settlement.
No, for now only. Just for breakfast.
When she, when
For
she-
morning tea.
yeah, when she left the family home, she took 9 lakhs. Your Lordship. 9 lakhs she took in cash.
But you are not paying for
But
this.
whatever it is, I have to pay. As per the law, I have to pay, but if it is
No,
the amount.
they're refusing.
The amount.
You come with a figure by Thursday.
Yes.
If you don't come with a figure by
I'll
Thursday,
come with a figure.
we know how to deal with it.
Your Lordship, I'll come with a figure that the amount which I'll be comfortable with, it, which I can somehow.
And it should be reasonable.
Yes,
It should not be unreasonably
yes.
low.
But yes.
It can be
cannot-
unreasonably high,
Yes, Your Lordship.
but not low.
Yes, but according to my earning, I can come to it.
According to your assets. You
Yes.
see,
I don't
Yes,
have
Your
any asset, Your Lordship. I don't have
False.
any asset.
Absolutely false.
I don't know.
Your Lordship, all the assets are, I have at most space sufficientness. And
Even
beyond that, I don't have any property of my own.
even the registration of class 1 is in his name, not in his father's name. False statement.
Everything is done by my father.
So says someone who owns luxury cars.
How can your father do? Your father is a government servant.
Yes.
No, he has retired.
He retired.
So after retirement.
No.
So
I will bring the registration
all the
certificate.
contract work were done after retirement.
Yes. And now, Your Lordship, because of the.
And how old are you?
He must be around 36, Your Lordship.
36.
Around
And the
36.
father must be around?
Father is around 70. Between 70 to 80. Between 70 to 80. The father.
Okay, anyway, okay. So that is basically your case.
Yes,
I have no other side.
Just my case here is only against the decision of the village council. I'm saying the village council.
So this is the law that you have brought.
Yes.
This is the law that we have brought out. The only issue is whether you should be divorced under the customary law
Yes.
or under the Indian Divorce
Indian
Act.
Divorce Act.
When the marriage
When the marriage
has been performed in the church.
Not has been performed up to the act. As your
This is a different tack altogether now.
So then your second marriage is also not valid.
Whatever, but then if this particular marriage, this declaration by the village is set aside, then the second, it will amount to setting aside the second marriage also. Your Lordship.
But
Now-
that does not take away the fact that even in live-in relationships, you still have to pay maintenance.
Your Lordship, that is that.
And
that-
especially maintenance for your kids.
That for with regard to maintenance.
You cannot escape. You cannot
No,
escape.
I'm not saying,
Either way, you cannot escape from paying maintenance.
maintenance will have to be paid, yes, Your Lord. That is it.
So,
What amount?
so that is
the
the
question. Yes.
that is the line that you always have to keep
Yes.
with your client. You tell him that we cannot escape our liability of paying maintenance, even though the
That-
village council might have said this.
Yes, that they are aware. Your Lordship, they are aware of that.
No.
Maintenance has to be paid.
And any customary law which is in violation of the constitution has, cannot be sustained.
Your Lordship. I am not saying that I even down below in the lower court also, I'm not saying that I am not liable to pay maintenance. I am only saying that it has to be reasonable, fair, just. That is my only case.
Please come on Thursday with a figure.
Your Lordship.
With a figure and with an intention to pay immediately within 1 week.
Your Lordship, I'll do about it. And then secondly, if a lump sum amount, one time amount can be settled, then I will.
The first part is only for the period you're not paying,
Your
and
Lordship.
the lump sum will be separate.
Your Lordship.
You'll also talk to your client.
I'll do that.
Yes.
Chalo, on the prayer of the parties, list the matter on Tuesday, on Thursday. Come on which, you all are not producing your clients, no?
May not be possible, Your Lordship.
If this court deems necessary, I can,
You know,
I can.
I like your attitude. Only problem is, I don't know if it's genuine.
No, it's genuine, Your Lordship.
Because he might come and not give anything. We want someone who will give something to the wife, ex-wife, and to his two kids.
In fact, that is what he's saying in the law, in the family code. Not entitled to anything.
Tell him that, he has to pay.
Yes.
He has to pay. This also in the file. Good. Anything else? Finish. Good. Oh. Okay.
My glasses. Voy a leer. Te voy a leer. Bunu gibi var. Ya, bueno.